Uh, may I please, your lordship? My lord, I beg to mention item number 7, my lord. My lord, what has happened, my lord? We have missed the item because, my lord, my name has not been shown and my colleague's name has been shown, so we missed it, my lord.
What do you mean you missed it? We can do it together.
My lord,
We can do it together. What is it? It's a small matter.
my lord, some
Your issue is only that
retro,
your service period as an honorary teacher.
my lord, should be counted or not.
That's all.
So, my lord, one,
There is nothing to really tax your brain on this.
no, my lord, there are certain judgments has been passed delivered by the Honorable Apex Court, my lord, on the issue.
Where? I doubt.
My lord, that's why, my lord, even, my lord, no, my lord, even the brief is also not with us today.
No,
My
we
lord, may
cannot-
take it up as day after, my lord.
We'll take it up tomorrow if you're ready.
My lord,
Tomorrow.
my lord.
That is just long and short of it.
My lord is going to dismiss my petition tomorrow. my lord.
Most probably.
Most probably. I'll try to
You
satisfy.
can bring some judgment in your favor.
I'll try.
Because there's nothing beyond that. Right. It's your name is not here.
My name is not here. That's why, my lord, I have no, my lord, we have, it is under my signature. It had been filed, my lord, but my name had, Wakalatnama is there, my lord. It was a delay condonation application that was condoned, my lord. Then it has been numbered. Today it has been listed first, my lord, without showing my name, my lord.
Mr.
A.R. Bhuya, my lord.
A.R. Bhuya, learned counsel for the appellant, submits that as his name was not in the cause list, he had
Mal.
missed the matter. He had not prepared the matter. Accordingly, let this matter tomorrow. The issue pertains to the appellant's prayer for payment of arrears salary. During the period, he was working as an honorary teacher.
My lord. Before regularization.
Before regularization, which was on 31/3/22.
Mal.
This is the matter tomorrow.
Obliged.
Okay, may I please for listing of an eye on Monday or not?
In item number 21, my lord, yesterday we filed our affidavit in opposition, my lord. That may be called for, my lord.
Obliged.
May it please your lordship, I beg to mention for listing of criminal appeal 362 of 24. Lordship paper book is ready, therefore the matter may be listed on next Wednesday, 17th. Oblige, lordship.
May I please, your lordship? Lordship, I beg to mention item number 19, lordship. With the consent of the other side, lordship, we will file objection in the IO, lordship.
You want to file objection?
Yes, lordship.
Why? 7 days only.
Under 11 days, but the explanation is not proper, lordship. They have only
When will you file your affidavit?
within 1 week.
Miss
M. Sharma.
M. Sharma appearing for spell number 5.
Yes, lordship.
Submits that she will be filing written objection to the application for condonation of 111 days by the next week. Accordingly, release this matter after the week.
Highly obliged.
May I please, your lordship? My lord, the present petitioner, my lord, has been filed by, my lord, one of the very active, my lord, Goria Council, my lord, which is a, my lord, wing of a their main, my lord, organization, my lord, the All Assam Desio Goria Jatiya Porikhot, my lord. Now, my lord, what has happened in this petition, my lord, basically our contention is that, my lord, in the state of Assam, my lord, the state government has bifurcated the particular community believing in a particular faith, my lord, that is the Muslims, has been bifurcated into, my lord, 2-3 categories. And we fall in the category of, my lord, indigenous Assamese Muslim community. My lord. Now, my lord, the policy of the government, my lordship is well aware, my lord, that the eviction drives in the entire states, my lord, are going on. my lord, but from those evictions, my lord, there is a conscious decision on the part of the government, and the, my lord, statement is also coming from the honorable head of the state that, my lord, the Garia community people are not going to be disturbed or they are not going to be evicted, my lord. That is the policy of the government. But despite that policy, my lord, notices has been issued. And in particular area, my lord, even, my lord, the mandatory requirement of the notice period has also not been followed. And our houses has been demolished overnight, and we have been, the community people had been, my lord, made homeless, my lord. That is also one, the basic contention of the challenge, my lord. And secondly, the state cabinet, my lord, has by taking a detailed policy, my lord, by way of their policy decision, my lord, that the certain recommendation has been made, sought for, and those recommendations are still pending. That has not been given effect to, my lord. That is the, my lord, second round of grievances, my lord.
So your first round is what? Your first,
First ground is, my lord, that the eviction drive which has been carried out in the entire state, my lord, the state government has excluded this community that is called Garia community, my lord.
they exclude,
My lord, it is their policy, my lord. It
where
is
is the written policy?
No, my lord, the policy the honorable chief minister has said, my lord, huh? My lord, may kindly turn to page page 98, my lord. Ninety-eight to 104, my lord, is the statement of the honorable chief minister, my lord.
No, no, Mr. Counsel, can we go into those issues, what he has said, what he has not said? You see, the issue is this. We are only we're only going to look into the issue whether the eviction is being done as per law or not.
My lord, as per law, if the state government, my lord,
If you are an encroacher,
my lord,
whether you belong to this community or that community, can there be a discrimination?
that is the issue, my lord,
That is, so that the issue is not that. The issue is
my lord.
whether you are an encroacher or not. First of all.
No, my lord, as per the state of Assam, my lord,
Just because Mr. A has been evicted
my lord,
does not mean that Mr. B should not be evicted. If A is evicted, B should be evicted. Okay, if they are both encroachers.
my lord. But my lord, the government has,
It is your case.
my lord.
You are not an encroacher. Then it's okay. But is it your case that you are not an encroacher?
No, my lord, our case is that, my lord, no doubt, my lord, in some of the government land, my lord, some of the government land, people are there residing from last 40, 50, 60, even 100 years, my lord. We have those records. Now, my lord, in those cases,
You have the record.
my lord, the individuals who are residing there in, my lord,
Then you go to the government with your record. Where is your records here? Let us see. Is it?
my lord, those records we do not, my lord, we do not, because those individuals, the community people are residing there in, my lord.
Mr. Counsel,
My lord,
we have to see whether each of the petitioners here
my lord.
are encroachers or not.
No, my lord, petitioners is a association representing those people,
So-
my lord.
But then if you are
My lord.
representing those people,
My lord.
you have got to show that those people you are representing, each and every one of them is not an encroacher.
No, my lord, if,
You cannot come to this court and say, though we are since we are encroachers and since we belong to this community, the law should not be made applicable to us.
no, it is, my lord, once the government has made a policy, my lord.
Where is that policy?
That policy, my lord, written, my lord, may kindly appreciate the recommendation of the cabinet, my lord, the subcommittee which the government has created, my lord. My lord, may kindly turn to page 39, annexure 1, my lord. My lord, may kindly turn straight away. I would like to draw my lordship's attention to page 79, my lord. Hmm. May I read, my lord? Recommendation with the direct government involvement, recognition of the indigenous Assamese Muslim as an indigenous Assamese speaking community of Assam. The Assam government through a notification may recognize the Assamese Muslim as an indigenous Assamese speaking community of Assam. The 5 subgroups of the Assamese Muslims, Sayad, Goria, Moria, Defi and Julha should be clearly mentioned and recognized in the government notification.
Okay,
This,
that is all right.
my lord,
That is
now,
all right. They
my
may
lord.
be recognized or not, that is a different issue.
my lord,
The
my lord.
issue right now before this court is whether you are encroachers or not. We are not going to protect you just because you belong to this community. If you are an encroacher, you are an encroacher. Whether you belong to, get Assamese Muslims,
My lord.
Assamese Hindus also, if you are an encroacher, you
No,
are
no,
an-
they, my lord, the Assamese Hindus are very much well protected within all the area.
You see, that's a
So
different.
now, my lord, those people are untouched. Those, my lord, we are not saying, my lord, that an individual should be evicted, my lord.
If you want, we'll make an observation that the Assamese Hindus also,
My lord.
who are encroachers, they should also be acted upon.
No, my lord, we are not for that prayer, my lord. We are not for that prayer, my lord,
See,
because
the thing is,
maximum, my lord, with all respect, what my humbly beg to submit, my lord, all these people are down to road and irrespective of their caste, creed and religion, my lord. My lord, may kindly appreciate, my lord, these people has been made homeless overnight. Even the, my lord, the notice period which has been fixed by the Honorable Apex Court in the Jamiat case, my lord, that 15 days notice period has not been followed, citing the reason that these are forest land. The Honorable Apex Court, my lord, in paragraph 98 of that judgment has categorically said, my lord, that in what type of land and in what area this judgment is not applicable. But in the area, my lord, wherein this demolition exercise has been carried out or going to be carried out, my lord, that, my lord, they have not given the benefit of that judgment, my lord.
no, so you want 15 days notice, that's
My lord, whatever the procedure of the law is there, my lord, that procedure should be followed, my lord.
no, so according to you,
My lord.
as per the Supreme Court judgment, 15 days notice should be given to the
Notice, my lord.
persons they are representing.
My lord, that judgment, if my lord may be pleased to, my lord can peruse that judgment, my lord. Sir, a copy. No.
Yes,
My lord, may kindly turn, my lord, to the. Sorry, judgment को ਦੱਸਣਾ? Page number 121, my lord. It is the, my lord, 2024 SCC online, SC 3291, my lord.
yes,
This is arising out of a writ petition civil number 295 of 2022.
Hmm.
My lord, I straight away I beg to draw my lordship's attention, my lord, to the operative part of the judgment, my lord.
yes.
Paragraph 98, my lord.
Ninety-eight.
My lord. My lord can find it from paragraph 90, page 166. I'm sorry, my lord, page 166, it starts, my lord.
3291.
WTC 295.
It's 3291.
My lord, may I read, my lord? The direction starts at Roman 9, my lord, para 90. In order to allay the fears, sorry, my lord, in order to allay the fears in the minds of the citizen with regard to the arbitrary exercise of power by the officers of league official of the state, we find it necessary to issue certain direction in exercise of power under Article 142 of the Constitution. We are also of the view that even after order of demolition are passed, the affected party needs to be given some time so as to challenge the order of demolition before an appropriate forum. We further of the view that even in cases of persons who do not wish to contest the demolition order, sufficient time need to be given to them.
Yes, so 15 time is left.
15 days time, my lord, may kindly see the notice.
So that's all.
No, my lord, after the notice, my lord, there is another process has been, my lord, given. My lord, may kindly see the notice shall contain the detail regarding. Thereafter, my lord, personal hearing, clause B, final order, and this final order is also required to be, my lord, an appellate authority or, my lord, it should be by of a judicial review exercise should be allowed to be given to the affected party. So this is a procedure under Article 142, my lord. So this is the law at the moment, my lord, governing the process of demolition or eviction in the entire country, my lord. So, my lord, in what type of, my lord, land this is not applicable, that has also been given, my lord. My lord, may kindly find the para 96 at page 168, my lord. No, agree to কথা ছিল order to applicable no হবে না। My lord, another important aspect is para 95, my lord. Para 95, the registered judicial is directed to circulate a copy of the judgment to the chief secretaries of all the state, union territories and the registrar general of all the high courts. All state governments shall issue circulars to all the district magistrates and the local authorities intimating them about the direction issued by this court, my lord. So, my lord, therefore, this is a binding judgment, my lord.
You know, all Supreme Court judgments are binding.
No, that is, my lord, with all my, my lord, limited, my lord, knowledge, my lord, what I respectfully beg to submit, my lord. But the state is not, my lord, following herein, my lord. That is the issue, my lord.
Notice has been issued to you, I think.
Yes, notice has been issued, my lord. In certain cases, notices has been issued.
Then
Only giving 7 days time, my lord. Only giving 7 days time. And those notices, my lord, may kindly see the language of the notice, my lord. Kindly see, my lord, we have annexed,
you see, once
my lord.
very outset, it is your case that you are an encroacher.
At least to be, my lord.
It is your case that you are an
My
encroacher. Your only case is that since you are of the Goria community,
My lord.
you should be exempted because the chief minister has said that you should be exempted.
My lord. That is the policy of the government.
Should this court follow the chief minister just because you are of the Goria community? If you are breaking the law,
No, my lord, as a,
if you are an encroacher,
my lord.
if you are an encroacher, you are an encroacher. What is wrong in the eviction of an encroacher?
No, my lord, with all respect, my lord, and even if my case is going to be dismissed, my lord, the honorable chief minister cannot override the constitution or the law, my lord, of his own.
We'll direct that
Of his
50
own.
time should be given.
And my lord, the procedure or the guideline, my lord, which is required,
Then
my lord, to be followed, my lord, that should be followed by the department, my lord, by the officials who are, my lord, issuing these notices, my lord, for the purpose of eviction, my lord. And my lord, may kindly see the notice, my lord. It is actually not a notice, my lord, it is an order. Huh? My lord, kindly see page 106 of my petition. No, notice to the
106,
My lord, 106. 108, my lord, may kindly take up.
108.
My lord. এখন দেখবা না, এখন দেখালে হবে। কোর্টত কেনেকে হেৰি কৰিবলৈ গম নোপোৱা নেকি?
107,
My lord.
6.
My lord, we have start the notices from
It is
10.
notice for eviction of illegal encroachment.
My
You are illegally cutting down forest area.
It is the allegation. My lord, may kindly see, my lord, 103 I am referring, my lord. Notice to Mr. So-and-so, notice for eviction of illegal encroachment in the Rangma Reserve Forest. You are hereby informed that you are illegally cutting down the forest area in the Rangma Reserve Forest area under the Uriam Ghat Regional Forest Office by building houses, planting battle nut and other commercial trees, digging ponds, constructing shops, by destroying the forest land into agricultural land, etc., and destroyed its resources. So, my lord, this is purely an allegation to a person that you are committing this thing, so you evict.
Basically, you want, as per the Supreme Court judgment,
My lord,
that 90 should be followed.
my lord.
That's all.
Para 90 should be followed, my lord. We should be given the opportunity.
Okay, we heard you. Para 90, okay,
Hello.
para 90 should be followed. That's all.
My lord, one thing we have not annexed in this petition, my lord, what has happened, my lord, during the pendency of the division bench to annex, my lord, the honorable division bench headed by the honorable, my lord, My lord, may be pleased to find at page 234, my lord. Already there is an order had been passed, my lord.
Yes, yes,
Page 234, my lord,
yes.
which I need to bring to my lordship's kind notice, my lord. My lord, a detailed guideline had already been issued, my lord.
Yes, yes,
Starts at page 236, my lord.
yes. Give us the relevant paragraph.
My lord.
The relevant paragraph is paragraph 21, page
My lord,
241.
241, my lord.
241, paragraph 19, 21.
Para 21, my lord. We would also like to observe that henceforth, if such drive is undertaken for clearing the reserve forest area of all enforcement, and if it is found that there are some settlers, even though unauthorized, they ought to be given a reasonable period, my lord.
Same thing, 15 days.
But my lord, the other procedure, my lord, which has been given, my lord, we are not on
We-
that, my lord.
We'll follow this one.
My lord, and this, even this judgment, my lord, even this judgment, my lord, has been again challenged before the Honorable Apex Court.
This order that we are going to pass also.
My lord, no, my lord, the division bench judgment which has been, my lord, passed by this Honorable Court has been challenged in the Apex Court, and the Apex Court order is at page 244, my lord. My lord.
Yes. But then that does not cover this case as on.
No, my lord, in this case, my lord, our basic contention, my lord, as the Garia community, my lord, has been taken care of very deliberately, my lord, by the government. And my lord, we have been decided to be not to be evicted, my lord. Now, after the,
First of all,
my lord,
you are not the affected person.
no, we are not, my lord, we are not,
The affected person come.
my lord.
We do not know. You do not have any documents in your favor or attested to this, annexed to this petition, saying that you have got a right to be there in that forest.
No, my lord, the forest rights, my lord, those are the issues, my lord, which has already been, my lord, averred in the writ appeal, my lord, which the honorable division bench headed by the honorable.
See,
Chief
those
Justice
are,
asked, my
those,
lord.
those are, if you are having a livelihood, you cannot cut down trees and decimate a forest like that.
No, that is, my lord, as a,
Well, you must have, in the, I think it was in, the Kerala,
my lord,
NALSA program, what Justice Surya Kant had said regarding
my lord,
cutting down of trees. And,
my lord.
Para 24, page 2. Anyway, so that is, you basically want 15 days notice.
My lord.
15 days notice as per the judgment of the Supreme Court.
And the other procedure prescribed therein, my lord. Or my lord, my lord may say, my lord, if I can satisfy my lord, then only I can pray, my lord.
Satisfied me. That judgment of the Supreme Court is
My lord.
followed. You are satisfied that.
My lord, my lord,
So judgment of the Supreme Court has to be
followed, my lord.
Yes. Lordship, my first submission is that this writ petition is not maintained. I'll deal with every argument he has made. So Lordship will kindly see, this is an association which is called Goria Moria Gofuripat. At Lordship, page 4. All Assam Goria Juba Chhatra Parishad having its office so and so. And if Lordship is pleased to come to paragraph 1, 2, and 3, there is absolutely no particulars regarding whether it is a registered or not unregistered. In that view of the matter, there is a standing order of this honorable court by a division bench. By division bench 2010 5 SC GLR page 332. Yes, Meghalaya Wine Dealers Association versus State of Meghalaya. by my Lord Justice Bhaipe and my Lord Justice H. Borua. Paragraph 16 of this judgment. If Lordship allows, I can read the paragraph.
Yeah.
Okay, getting a separate.
This is the association or what is this?
This is an association, unregistered association.
Milord, with all, Milord, this is an, this association is not registered, but the main organization, Milord, which is the, Milord, this is the brother organization of that Boria, Moria, Deshiya Jatiya Porishad, Milord. These are the youth wing, Milord. Like the, Milord, student association is now there.
Petitioner,
Milord.
it is not a registered association.
It is not a registered, but they are espousing the cause of the down to road and, Milord, the very marginalized section of the society,
But they are
Milord.
not a registered association.
No, Milord. This is not a registered, Milord. And we have also judgment, Milord. Under various circumstances, Milord, the Honorable Apex Court has held, Milord, that when, Milord, the spouses of such, Milord, down to road and marginalized section of the people are being spoused before an honorable constitutional court, Milord. And,
By who? By who?
my lord,
By who? Espousing by whom?
espousing by this type of organization, Milord.
Organization of the.
Judgment
Milord, today, Milord,
today
today I have not read it, Milord.
and unfortunate.
Milord can take it up tomorrow, Milord. I'll
No, we
satisfy.
don't have time. We have got so many cases, Mr. Khan.
No, Milord, Milord, this maintainability issue, Milord, which has been raised, Milord. So, my lord can give me one chance to, Milord, to satisfy the maintainability, Milord.
No, not after wasting so much time. Yes, next.
So-
case.
The case which my learned friend has argued before the division bench as well as the single bench, Lordship will find at page 234. This is a batch of cases where
234.
all individuals came.
Yes.
Page 234.
Yes,
The all individuals whom now my friend is claiming to are representing. So those who are affected, they have already approached for the same council.
So they have formed an association.
No, they have not from this. The form was for this association is
Association, but
old.
association.
The parent association, if I have to believe my learned friend's statement, I am not sure that whether this is a
No, so
brother
these-
organism or sister organism.
these petitioners, these appellants,
Yes, they are identically placed.
234.
Same reserve forest, Rengma in Uriam Ghat. And the same council represented before the learned single judge. The learned single judge extended the time by 7 days. Initially 7 days time was given. It was extended to 14 days. Against that, they went to the division bench and division bench allowed 15 days time. So that is the background.
Milord,
And the Supreme Court case, I have to go through it, whether that is in respect of forest area or a government land, house land. There are two different sets of order from this honorable court regarding forest, because if a person encroaches a forest, that itself amounts to an offense. Immediately under section 24 and 25 of the Forest Act, it is an offense and they should be actually put behind bars.
Assam Forest Regulation.
Yes, Lordship. May I read it? Section 24
That
and
is-
25.
Regulation 24-25,
Assam Forest Regulation 1891.
1891.
Yes.
So para 24 of the judgment they have.
Yes, because these were argued. That's why I'm very,
That's already there.
it is already there. So it is an offense. So therefore, actually the forest regulations or any other forest law, there is no contemplation of a eviction process. But in the revenue legislations, like the 1886 Assam Land Revenue Regulations, there is a eviction process under Regulation 18. So there is a huge difference between forest land and then normal government land.
Case has been cited. It is regarding commercial.
Here to there.
They are
They are
regarding,
starting
residential
commercial activities in the forest. There are shopping malls. Everything is demolished. Now my learned friend also started his submission by saying our houses were overnight demolished. So nothing survives in this case. If they want to have any compensation, a separate cause of action will come up. Let them file that writ petition. So the issue is already settled. Number one. Number two, the writ petition, this PL is not maintainable. Number three, the Honorable Chief Minister has not made any that kind of statement. I can give hundred of examples where communities from all religions, all castes, all communities are evicted. I can give the straight example of Ilhaku Amsang.
No, anyway,
Everybody
that is not an issue.
That is, if they are trying to project it. This is their endeavor that
Even if.
the category of persons are
even if the
evicted.
CM had.
It is not said. It is not said. What the CM has said, Lordship, that those who have acquired the forest dwellers right under the 2006 Act, that means they have to be there for 3 generations. That means 75 years. Those who will acquire a forest dwellers right, these are not that kind of category people. So wrong statements are being made. So I am clarifying this. And in that view of the matter, Lordship, no direction may be passed in this case because the writ petition or the PL itself is not maintainable in its present form. And I am ready to argue the matter on maintainability. If my learned friend wants to argue that,
There's nothing much. Only one thing.
And-
The AG had said
My lord.
that you had said that your houses have been demolished.
My lord, this is a Pan Assam PIL covering, not, my lord, because this community is, my lord, covering the entire Assam, my lord. Now, my respected Advocate General has cited, my lord, the area of Rengma and the other part of the Gulaghar district, my lord. Even the houses,
which they have annexed in the petition.
my lord, in the mid of the city, my lord, it is an area called Kotabari. There are certain section of our people are residing there in Lakhimpur, my lord. There are certain people are residing of this Goria community, my lord. They have been targeted. And the person, my lord, concerned who, my lord, I should not utter this word, belongs to some other religion, my lord. They are my neighbors, my lord, my neighbors. My lord, they are being protected. Very unfortunate, my lord. They are being, their houses has not been touched, even though they are residing there in, my lord. Even video footages and examples, photographs are also there. The structure is still standing. Only because, my lord, we belong to a particular faith and community, my lord, our houses has been bulldozed. My lord, may kindly appreciate the dreams of thousands of people are being shattered overnight, my lord.
Let them come. Let those
No,
individuals
Milord.
come.
My lord, those people are so marginalized, my lord, so marginalized at this moment, my lord. They do not have food, shelter, clothes, even, my lord.
Let them come in their own individual names.
Women are finding it difficult to give birth, my lord. The ambulances are not being allowed to enter into those areas, my lord.
One
My
individual
lord.
is occupying 300 bighas of land. One individual.
My lord, we are not for them. This person concerned who has been large scale, my lord, enforcement, my lord.
We have got to take the case on individual basis. We do not know unless we do not know whether what you're saying pertains to A or it pertains to B or pertains to C. How many persons are you representing?
My lord, the entire Goria community
How
in this
many
state,
is
my
that?
lord, those.
How many? How many?
My lord, the report says, my lord, the report says.
To you, how many?
My lord, it
You do not know.
about, my lord, near about 10 lakhs to more than people are, my lord, or there,
To decide the issue.
my lord.
Well, in one sweep,
No, my lord, that is,
whether 10 lakh people who are encroaching or not.
no, my lord, we are not saying that the 10 lakhs encroachers are
is
there.
Is there 10 lakhs notices have been issued or not?
No.
No.
Notices.
How many notices have been issued?
My lord, the notices which they have issued, they have areas in,
We cannot go, you see, let them come individually. You take up 100 cases in the case, individual names. You cannot come in a.
by this PIL, my lord, by this PIL, our grievance is very limited, my lord. That the policy which the Honorable Chief Minister has been publicly made, that we are not going to disturb this community people, my lord. Even then, I know, my lord, that there is no any cabinet memorandum, notification has not been issued. It is only a verbal assurance before the media. Now, my lord, the person, my lord, the houses which has not been demolished, because they belongs to a particular faith and we belong to a particular faith, for that reason only our houses should be demolished. My lord, this is a pure unconstitutional, my lord. My lord, this is the state is enforcing the constitution, my lord.
Lot of things are being said
Why?
without there being any pleadings.
No, my lord,
Let them.
we
plead
can,
the
we can,
facts.
we can bring it on pleadings also.
Two individual, they can always, we are welcoming them. Because in Lakhimpur, lot of Hindu community people were evicted. It was in the memes, it was in the social media. In the Amsang, 900 Hindu families were evicted. In Silsako, 700 families were evicted. All are Hindus.
Lakhimpur and Amsang.
Amsang, Silsako, border. All are Hindus.
And my lord,
In- The PIL is a suo motu PIL of Amsang by this honorable court. There we have
Anyway,
removed 900 families. Still there are some left.
Anyway, I think we've heard.
It is an incorrect statement they are making.
I think we've heard enough.
Communities, cultural backgrounds, and the religions, irrespective of everything, who is encroaching government land, who is encroaching forest land, They have to face the music. It is as simple as that.
My lord, with all respect to my learned,
Now election is coming, all types of
My-
political narratives are being promoted.
we are
And
not-
this will be shown in the, in the evening in the social media. This
absolutely,
video.
absolutely not.
This is happening, this is
Absolutely not.
happening, and same statements will be made in the television channel also.
The issue is this.
This election is coming, all these are politically motivated PILs.
Not going into the issue of whether a person belongs to this religion
Right,
or that
faith.
religion.
My lord.
We are only taking into account the issue of whether you are an encroacher or not. And then you make your reply. Individually, you make a reply,
My lord.
whether you are an encroacher or not, that's all. And for those,
My lord can dispose of the PIL, my lord, with a, if I can satisfy only, my lord, then only I can pray, my lord. Because this community, my lord, I have personally visited certain areas, my lord. These people are now residing in the streets, my lord. Very unfortunate, my lord.
look,
My lord, Olga Tellis says, my lord, Olga Tellis says, the Honorable Apex Court says,
council,
my lord,
we are speaking in two voices.
my lord,
You are speaking in two voices.
my lord,
First of all, you want a notice. Okay,
my lord.
15 days notice. On the other hand, you're saying that they're sleeping on the streets. That means the houses have been demolished.
Some person's house has already been demolished without following any.
It is for them. Now what?
Still some are surviving, my lord.
Can
Still
we,
some
can
are
we,
surviving,
can we tell the respondents,
my lord.
let them go back to the forest and encroach the forest land?
At least, my lord, some alternate arrangement, food, clothes and shelter, the state being a welfare state, they are also citizens, my lord. Before demolishing,
Let
my
those,
lord,
let those individuals come. They will look.
We have a straight way of land policy. Those who are landless, those who are flood affected, those who are erosion affected, they are entitled. All these people are going to their native places in Kachar, to Nagaon district, to Morigaon district, and to Dhubri district. They all have land and original places. These are additional, they are designed way, they are encroaching the forest.
One way to
But these are all facts. What I am submitting, these are all facts. In the affidavit we have seen.
Let them, let if,
All the people who are evicted, they said, where are you going? I am going to my native place in Nagar. This is the statement. All are recorded.
my lord, these are, some people may.
Yeah, now some people.
may, oh, no, we do not have man-to-man survey, my lord.
We have the
My lord,
man to man.
you see, it's very hard for this court
My,
to
find out, my lord.
your issue
My lord.
with one stroke of the broom or one stroke of the pen or one stroke of the brush, whatever.
How can a person from Kachar district go and encroach in Lakhimpur
Anyway, we are not into
with
that.
groups, with a racket? They are doing this. And our forest officers also, we are taking action against them. They were sleeping, they were in deep slumber. They have to wake up now.
My lord, human being will always migrating from here.
Yes,
to
that
there.
is, I also accept. From Mexico to USA, there is a constant inflow. But there is a process. There is a process. And if the process is broken, how the Indians were sent back from USA?
There's a procedure.
There is a procedure.
On behalf of Forest Department, I only one submission to make. That judgment my learned friend is relying on Honorable Supreme Court. Because this PL malab has club, forest land, revenue land, government land, everything has changed. The judgment malab, paragraph 1 is good for us.
It's a commercial land, residential commercial.
No, my lord, will kindly see what was the background of the Supreme Court. That portion has not been placed, it's a displaced judgment.
No,
Paragraph 1, my lord, will see.
Displaced, can I go?
Paragraph 1, this batch of writ petition
That's what I said.
filed under Article 32 of the Constitution of India seeks to raise the grievance on behalf of various citizens whose residential and commercial properties have been demolished by the state authorities without following due process of law on the ground. What was the ground, my lord? On the ground of them being involved as an accused in criminal offence. Now, paragraph 2, my lord. The petitioner internally seeks directions to the Union of India and the concerned states, directing them that no precipitative action be taken in respect of residential or commercial properties of any accused in any criminal proceeding. Now, my lord, what was the ambit of the proceeding? Paragraph 12. That is all, my lord. My lord, can you turn to paragraph 12?
Paragraph?
12 of that judgment. His judgment has no application in the present case, my lord.
And the guidelines also removes the area of forest land or public road.
Yes.
All these areas are exempted from that judgment.
Exactly. Paragraph 12, my lord. The scope of the present petition is limited. I read, my lord.
Yes, sir.
The scope of the present petition is limited. The question that will have to be considered is as to whether The scope of the present petition is limited. The question that will have to be considered is as to whether the properties of persons who are accused of committing certain crimes or for that matter even convicted for commission of offences can be demolished without following the due process of law or not. So that petition was confined only to this category of persons who were either accused or convicted in criminal offences and their houses were being demolished. So this judgment has no application whatsoever with the forest, my lord. If a person, my lord, cannot enter into inside forest, my lord, for even a second without permission, my lord, how can they? Otherwise, they are not entitled for notice.
Anyway, no, you see, anyway, in that judgment passed by this court,
But
But,
why I'm saying, true, man, what I'm saying, my
already
lord,
15 days has been given, so we'll give 15
And
days.
that is
Okay.
specifically to the forest areas.
Give 15 days on.
why I'm saying, my lord, because this is the plea they have again taken in Honorable Supreme Court. This represented the fact that these are the different lines, my lord.
Anyway,
No.
These are different.
anyway,
In Supreme Court, we will deal the matter.
Milord, what my,
we have heard, we have heard.
no,
And
Milord,
It's only, your arguments now are only for live streaming purposes now.
that is,
They're,
that
they're
is,
the
that
whole-
is, no, Milord.
watching this live stream,
I
but
get-
the issue is going to be the same. We are running around the same bush.
Milord, live streaming.
Sir, A.R. Bhuyan,
There are
Leonard.
Milord, may I clarify the issue which has been raised by
No, no,
additional
no,
AG,
no.
Milord?
We have heard y'all enough. We know what the issue is. We do not want any more deliberations on this issue because it's only a waste of time. The judgments are there. You are relying upon the Supreme Court judgment and
Division
the
bench.
division bench judgment. And we are going to pass an order in line with that.
Fine.
Heard Ms. Katria, Learned Council. Petitioner. Unregistered association. Person. So heard Ms. Learned A.G. Assam and Mr. Assisted by Mr. Aibor Pujari. Mr. Ian Goswami, learned additional AG. The forest department, appearing for the forest department. The petitioner's case is that the state respondent have illegally removed illegally demolished the houses of the members of the petitioner association who belong to the indigenous Assamese Muslim community in the state, even though the Honorable Chief Minister of Assam in his in his speech,
Milord, in media report, my lord, it is at page 108, Milord. No.
even though the Honorable Minister of Assam, where?
My lord, I'm. Media report. My lord, kindly turn to page 102.
Assam, in his speech which has been published in newspapers on 8/20/25, stated that the state would not consider unauthorized occupation of public land by indigenous people as encroachment. However, the state has not acted upon the decision of the Honorable Chief Minister, and they have targeted the Muslim community of the state of Assam by issuing them 7 days notice for eviction from the Rengma Reserved Forest Area under Umriam Ghat Regional Forest Office in violation of what have I said? No, just read the entire sentence. How does it start? No, for violating. Section, it won't be section, it will be regulation. Regulation 24 and 25
Assam Forest.
of the Assam Forest Regulations, 1891. Next paragraph. The petitioner's counsel submits that while some of the houses of the members of the petitioner as stated has been demolished after issuance of the notice, of the houses of the members of the petitioner station are have not yet been demolished. He submits, or they've all been demolished. What?
My lord, some of the petitioners has been demolished, but people belong to the other, my lord, community has not been.
No, that may be true, but I'm asking you,
My-
have all the.
No, not all houses, my lord, in this Rangma, my lord, most of the house. My-
So we also submit that similarly placed persons who belong to other religious groups who have also encroached upon Rengma Reserved Forest Area have not been touched by the state government. So that's an admission by you.
My-
Okay, first up. He also submits that in terms of the decision of the Supreme Court, Honorable Supreme Court, in the case of redirections in the matter of demolition of structures with uh, which is reported in 2024 SCC Online SC 3291.
my-
The Supreme Court had issued directions to be followed by the state prior to any demolition to be carried out by the state against unauthorized structures of citizens. It is and citizens. He submits that in terms of the said direction, a prior show cause notice of 15 days was to be provided by the authorities containing various details specified in para 91 of the said judgment. And a personal hearing was also to be given to the affected individual. It was only after the above steps were undertaken by the authority could the state take the extreme step of demolition of an authorized structure of a citizen. Next paragraph. The learned counsel for the appellant submits also submit that in a similar matter pertaining to the question of encroachment to forest land pertaining to the same Rengma forest, is it? Rengma forest and
My lord, huh? No, I got sir. Kuriam Ghat, my lord, Rengma,
Number is there.
huh?
number,
And south number.
number, my lord.
Where do we get that name?
It's not in the order.
Oh, okay. What? Rengma forest
And south number is there first.
and South Number Reserve Forest, comma,
The district of Golaghat, my lord.
comma in the district of Golaghat.
Well,
The division bench of this court, while order dated 18/8/2025, passed in WA 251 of 2025, brackets Abdul Khalek and 58 others versus State of Assam, State of Assam and others had directed that there is a drive undertaken for clearing reserved forest land of all encroachment. And if it was found that there were some settlers, there were some unauthorized settlers, they ought to be given a reasonable period of time of 15 days to explain under what circumstances they had set up their residence inside the reserved forest area, where any non-forest activity or their presence attracted penal offense. Or their presence attracted penal offense. It also held that besides the notice of 15 days, a further 15 days time would have to be given to such encroachers to leave the reserved forest land. He accordingly submits that a similar direction should be passed by this court. Correct?
Mal.
Yes, learned AG is agreeable, 15 days for notice and 15 days.
No.
for-
Only 15 days.
No, but out here you have also already agreed.
No, no. Whatever is there in paragraph 22, I fully agree.
No, please say 242.
242, yes, whatever is there, I fully agree.
Same.
This is a same order, but my first argument is that this petition is not maintainable.
That is another thing. But just go to
Otherwise, this is a,
82, para 22.
absolute lordship, I am not, we are fully complying this.
Next para. The learned AG submits that the present writ petition is not maintainable on account of the petitioner not being a registered estate. In this regard, he has relied upon the judgment of the division bench of this court in the case of Meghalaya Wine Dealers Association and another versus State of Meghalaya and others, reported in 2010, 5 GLR 332.
Paragraph 6.
Wherein it has been held that an association cannot file a writ petition unless it attains the character of a juristic person or a legal person by registering it under a statute. Next time. Is the submit that the fact that the petitioners are inquisitors having been admitted by the counsel for the petitioner,
My lord,
admitted that,
I have admitted that it is an allegation, my lord, not direct admission is like this. It is their
okay,
alleged, my lord.
he submits that as the petitioners are encroachers, as the members of the unregistered petitioner association are encroachers, are encroachers in the reserved forest, carrying out non-forest activity, they are liable to be prosecuted under regulation 24 and 25 of the Assam Forest Regulation 1890. He also submits that for those persons whose houses have been demolished, they always have a right to go to the civil court claiming damages if they have been evicted illegally. He further submit that there has been no discrimination in eviction of encroachers from forest area in as much as indigenous Assamese Hindus. No, indigenous.
On the basis of.
He submits that there's been no discrimination
On the basis-
in eviction of encroachers from various forest areas in the
Forest
state
as well as government areas,
in
government land,
in
caste land,
forest and government land.
on the basis of caste, religion and community.
Basis and community. He submits that persons belonging to other religions besides the Muslim religion have also been evicted
Throughout the state.
from the encroached land. As such, there is no discrimination practiced by the state. We have heard the learned counsel for the past. Though the petitioner's counsel has stated that only has stated that the members of the petitioner association should not be evicted from their land on account of the statement made by the Honorable Chief Minister of Assam. We are of the view that there can be no protection if a person is encroaching upon forest or state land illegally. Be it a person professing the Christian, Muslim, or Hindu faith.
One statement from my side. There was no such statement made by the chief minister.
Okay, one in that, you're right. The AG further, the learned AG further sub, that no statement had been made by the chief minister that the indigenous Muslim community in Assam. No, the encroachment of land by the indigenous Muslim community of Assam of forest land would not be considered to be an encroachment. Correct?
That is not a correct statement. My submission.
That's what I said.
Yeah.
But my lord, the only
That Whether he said that or that,
Mile.
the issue
This
is,
is print and wire.
the issue is
This
that
is no
No,
particular.
my lord, our basis is Press Trust of India.
the council, even if the chief minister says that,
My lord,
supposing he says that,
my lord, my lord.
supposing he said it, that
Law will
that
prevail.
cannot
Override the
be
constitution.
that not be a protection
My lord.
against the law.
No, that I
The
admit.
law has to be followed.
My lord.
Then
Article 14 is for all. my lord.
that's all right.
Fine.
Article 14, this way or that way, however they look at it.
And the forest regulations. They are encroaching forest.
Yes, yes, yes.
24 and 25.
Right. Next. Um, the law has to be applied equally to everybody, and in the event the members of the petitioner association are found to be encroaching upon forest land in violation of the stamp forest regulation 1891. The eviction of such encroachers would have to be would be justified. The question that is to be seen is whether the 7 days time period given in the show cause notice issued to the members of the petitioner association was sufficient time for the members of the said association to make a reply to the said note.
It is also not a show cause, my lord. It is just an order. You back
It
it.
didn't matter, it's deemed to be a show cause.
My lord.
Just the word, you have to use the word show, then it becomes show cause, huh? Okay, right. In the case of, in the case of, in the case of, in redirections in the matter of demolition of structures, Supra, the Supreme Court had directed that prior to demolishing a property, 15 days notice was to be given. Upon the owner / occupier of the unauthorized structure. The notice was to contain the nature of the unauthorized construction and details of specific violation and grounds of demolition. A personal hearing was also to be provided to the owner / occupier of the unauthorized structure. And only after the said steps had been undertaken was the extreme step of demolition to be done by the authorities. The issue that led to the guidelines being directed, being made by the Supreme Court in the above case prior to demolition of an unauthorized structure pertain to pertain to no, before the, no, pair 1 and 2.
Mostly 12.
Yes, pertain to. Pertain to. Demolition of residential and commercial properties by the state on the ground of them being involved on the ground of the owners of the said properties being involved as an accused in criminal offences.
But later on, it has been expanded to other parts. My lord,
Look, let me decide.
no, my lord,
Do not interject. Please do not interject.
my lord, para 91 has not been shown to my lordship.
That one may be seen, Lordship. I am going
In
to.
front of me, I'm reading it. What do you think I'm doing here?
My lord.
Not looking at your file, I'm looking at the judgment.
My lord.
Next. Stop. Now. In para 12 of the said judgment, it has been clearly stated by the Supreme Court that the scope of the case was limited and that the question that would have to be considered was as to whether the properties of the persons, who are accused of committing certain crimes, or for that matter, even convicted for commission of criminal offences, can be demolished following the due process of law or not. So, sub question mark. Next part. The issue here, no, the property here, but is with respect to unauthorized structure made within reserved forest area.
And
And
criminal,
not, had nothing to do with the, the said persons having any criminal cases against them. So stop. Be that as it may, in a similar case pertaining to the same forest area, pertaining to the same reserve forest, this court, coordinate bench had by order dated 18/8/2025 disposed of WA 251/2025 by holding that if a drive for reserved forest areas of all encroachments was undertaken, and if it was found that there were some unauthorized settlers, they ought to be given a reasonable time of 15 days to explain under what circumstances they had set up their residence inside the forest area, where any non-forest activity or their presence attracted penal offense. They were also to be given a further period of 15 days thereafter for exiting the place. This court further held that the same would, however, not protect the encroachers from being prosecuted for any penal offense committed by them in carrying out non-forest activity in the reserved forest area under regulation 24 and 25 of the Assam Forest Regulation 1891. Para 21 to 24 of the order dated 18/8/25 in WA 251 of 2025 is reproduced here below as follows. Page 241, 242. On considering the fact that the writ petitioner is an unregistered station, we are of the view that the writ petition is not maintainable in terms of the judgment of coordinate bench of this court in Meghalaya wine dealers section and another super.
Lord, we have the list of judgments, my lord, regarding that maintainability.
Give me.
And similar petitions are being adjudicated also. My lord.
Adjudicated, forget.
My lord.
Yes, which para? Don't give me just like this, no. Go to Supreme Court then. This is not the way, right? The above being said, comma, no, so that right, notwithstanding the fact that we find that the present writ petition, the present public interest litigation is not maintainable. We are of the view that as a similar issue had been decided by a coordinate bench of this court in WA 251 of 2025, the directions passed in that case could also be applicable, to be applied in, can also be applied to unauthorized settlers who are to be driven out from reserved forest area. After they are given a reasonable time, they're given a period of, they're given a show cause notice of 15 days to explain the circumstances under which they had set up their residence inside the reserved forest area, or where any non-forest activity or their presence attracted offense under the applicable laws. Thereafter, if the state respondents are of the view that that those persons are in process, a further 15 days time should be given to them to leave the reserved forest. With the above observations and directions, it can be according to this.
My submission. Good, sir, good is not a clearly performed. That has been observed and my submission.
Just after after the AG, the PN Goswami, learned additional AG appearing for the Forest Department, submit that the decision cited by the learned counsel for the petitioner, that is, in redirections in the matter of demolition of structures, is not applicable to the facts of this case, as the present case pertains to encroachment of reserved forest land, while the above case referred to the properties of persons accused of committing offences had been demolished without following the due process.
Obliged, highly approved.
May I please, Lordship? This case is actually covered case, my lord. The petition, covered case.
Covered case.
Yes, my lord. The petitioners are the non-teaching staffs of different schools and colleges. So already one judgment has been passed by this honorable justice. Kindly page number 28, 29, my lord. We are getting fixed pay, my lord. So judgment has been passed and directed to the government to pay the regular scale of pay.
And you are where? You are working where?
We are working in different schools and colleges.
You are working in different schools and colleges.
Yes, madam. As a senior assistant, grade 4, etc.
And but you are challenging the rules.
Well, already rules have been challenged and has been disposed of by the honorable Chief Justice.
Where is the disposal?
Kindly page number 28, madam. 29.
Take us to the relevant portion.
Para, my lord. 16, my lord.
16.
Yes, my lord.
But what about 6.2? Section 6.2 of the act.
It is, there are 6 days, my lord, the non-teaching staff will get the fixed pay, my lord.
Correct, then. So this, what did this court say?
Court says is they will directed to pay the regular scale of pay as the,
Were they covered by 6.2?
yes, my lord, already 6.2 is covered, my lord. Kindly read the,
But has the issue of 6.2 been taken up by the,
yes, my lord, 6, 1, 2, 3 and 4,
where?
all sections are covered. Para 9, my lord, page 31. And bunch of writ petition has been disposed of, my lord.
Yes, Mr.
Yes, my lord. 6.2 has not been struck down by the,
Correct, but then it has said that non-teaching staff would be entitled to equal treatment.
yes, my lord.
Then-
This order was based on a judgment passed in Mohor Ali Sheikh. That Mohor Ali Sheikh, we have, state has preferred a review, my lord, against the,
But till the review is decided,
yes, my lord.
then
But the bunch of petitions has been disposed of. They are all non-teaching staff of different colleges and schools, my lord. There are 4 writ petitions.
where are those disposed of?
It is a linked case, my lord. I have not annexed, I have the relevant portion. Kindly,
So is this a covered matter or not?
yes, my lord, covered.
Other is covered, my issue has
Issue is
already been.
covered.
Then
Simple order may be passed, my lord. We are covered in that judgment. my lord.
so they're covered by this judgment, so then,
Yes, my lord.
right, Mr.
A. Ahmed, Anacletus Ahmed.
A. Ahmed, learned counsel for the petitioners. And Mr. N. Khatri.
NJ Khatri, my lord.
But what about this 6.2? It's not mentioned, not required to be challenged. So why have you challenged it if there's not
We want to be parties in that order, my lord. We want to be party in that order, my lord. For further reference. If the government do not comply,
what order? To be in party in what order? Who's your senior? What is your name?
A. Ahmed, Anacletus Ahmed.
Not H.I. Ahmed.
No,
Where is H.I. Ahmed?
he's in different court. my lord.
Just call him. Let him come. Call him.
Just a simple order may be passed, my lord. We are covered by that judgment. Nothing.
Tell us then why did you challenge 6.2?
We are getting fixed, my lord, but we
Let us see. Just give me that the route. 6.2 of the
just we are getting fixed pay, my lord. That is the non-teaching staff will get the fixed payment. But already judgment has been passed, my lord.
Education, my lord.
what does 6.2 say? Any idea?
6 my lord, the non-teaching staff will get the fixed pay, my lord.
Non-teaching staff will get the fix.
Fixed pay, my lord.
They're getting fixed.
No, we are getting fixed pay.
Correct. Because of 6.2. Because of 6.2, you're getting fixed. Correct.
But the other same equivalent persons are getting full salary, my lord. We are government servant. They are getting full salary, so we ought to be have been given the regular scale of pay. We are the similar situated person.
Mr. Counsel,
Been silenced in that case, my lord.
you call a senior. You're not understanding. You call a senior. Maybe a simple thing, but you see, we are simple. We do not understand.
If possible for today, I will next date, my lord.
We'll call a senior today.
My lord, one date maybe I will.
Senior today.
Item 3, Your Lordships, I beg to appear through VC. This is a matter,
Item 3.
I'm for petition, Your Lordships. This is the matter, Your Lordships, of disability pension. Let me give a background of this case, Your Lordships. What has happened? I was invalidated out as a sweeper, Your Lordships. I am already getting invalid pension. I'm asking for disability pension, and even my department has sanctioned, your lordships. But PCDA has not honored the order passed by record office. So this is the only case before your lordships, and learning CAT, what they have done, your lordships, they have said this OM on which I have been relying before CAT, your lordships. They are saying this is much old, your lordship, this is old notification they are saying. That much water has flown in the river of Brahmaputra and Ganga. So this OM cannot be relied by your lordships. So your lordships, if your lordship would have page number 63, it would clarify the picture. Page number 63 for a while.
Yes.
It says your lordship, disability pension with invalid pension, Sri Anu Devi, which is the answer. The case,
Let us see the order whereby you have been invalidated out of service.
please, your lordship. I will take my lords to
TCS.
Your lordship, there are medical documents which were annexed by me before Honorable CAT, your lordship. So there is
Madam, look, please let us see the order which you left the service.
your lodges may have annexure 11.
Right?
It says page number 58, 58. Though this is again not invalid order or discharge order because that has not been filed, but it clarified the query put by my lords. Page number 58, annexure 11 is the I was disabled, permanent disabled, and was discharged with this 45% of disability, which permanent in nature. Suffer on top, your lordships, on right side, suffer rheumatic arthritic, and this was 45% permanent disabled. So I was invalidated with disability of 45%, which was attributable by service, your lordships. Page number 60 says I was this was aggravated by service, your lordships. May page number 60 for a moment. It has
So because of this, because of now you have been permanently, this is permanent disablement. So
I-
where is the order? Permanent, this is only with regard to your your
Please.
disability percentage. Where is the order sending you out?
Let me clarify. Just give me a moment, your lordships. What has happened, your lordships? They say their whole objection, and as far as CAT's order is concerned, they are saying both pension, invalid pension and disability pension would be eligible, would be entitled if the
We will go into that.
please, your lordship.
You see, the thing is that we are asking you for certain document. We are not answering.
Please, your lordship.
You don't want to answer. Why should we hear you?
Your lordships may have, because that invalid order or discharge order is not placed on record. Your lordships may have page number 62.
That
That
is what
page number 62, your lordship, that has also been issued by Medical Joint Director of Health Services only, because discharge order is not on record. If your lordships would permit, I will file on record. But as on moment, this is not.
documents are, that is the basis for the entire case.
Because what had happened, your lordship, I had sought voluntary retirement on the basis of my disability, my medical conditions.
You had voluntary retirement.
But with invalid pension, your lordship, because it was attributable to service. So I was very much entitled for the invalid pension.
Where is your application for voluntary retirement?
Your lordship, that is not actually in dispute, that I am already getting invalid pension. So I placed on records all the application where I have been asking for disability pension.
Madam, you and the whole world know it. The problem is we too don't know it.
I'm so sorry for troubling my lords, but
Yes, we are sorry also. List the matter after.
yes, your lordships may have it on 14th of October. I have other matters before your lordships. I will travel to Guwahati High Court if my lords may permit me, because I'm
14th of October.
I'm so grateful. I'm so grateful.
In the meantime, the counsel for the petitioner shall provide all the documents. That is her application for voluntary retirement and the certificate by which he was discharged out of school.
Very
Lordship,
well.
one more thing, this court might order dated 7/3/25 hours out of original PPO. That has also not been produced. till-
The petitioner shall also produce the original PPO on the
My
next day.
learned colleague is already having a lordship's wide order dated 8th of April 2025. My learned friend from other side was also
You
directed to
bring,
verify this PP.
you bring all those on 14th October.
Please, your lordship, I will do that. I'm so grateful.
Wait, please, Your Lordship.
My lord, this to appeal pertains to some Avon and Pollution Control Board. The matter relates to my lord promotion to the grade of Assistant Executive Engineer and above.
From
From
AE.
Assistant Engineer.
From AE to AE.
Yes. Now, my lord, what had happened, there are two sets of appellants, my lord. One set was promoted from AE to AEE and another set was upgraded from AE to AE, Assistant Executive Engineer.
From AE to E.
AEE, Assistant Executive Engineer.
One set promoted, one set upgraded.
Yes,
Both from AE to AE.
yes. Now, my lord, what had happened?
So promotion, upgradation, one is promotion. Upgradation, there's a post upgradation.
Yeah, no, my lord, along with the income. Well, there is a provision in the statute.
For upgradation. What does it mean? What do you mean by upgradation of a person? I can understand
No,
upgradation
my
of.
lord, normally upgradation is a concept which is exactly not synonymous with promotion. But my lord, upgradation is something in the exigencies of service, it can be done under the statute of the.
No, so what does it amount to? It amounts to promotion or what?
It amounts to, yes, in effect, it's a promotion, my lord.
But do they have to have the qualifying years of service, everything?
That they have.
And it has,
The qualification also.
and they have to go through a process of selection.
Actually, the only point to be decided in this case is, my lord, what had happened? The appellants are not degree holder, they are diploma holder.
The appellants are degree holders.
Degree holder,
Diploma holders are degree holders.
diploma holder.
Appellants are diploma holders. So your
Sole respondent, he is a degree holder.
Oh.
His only case is we could not have been either promoted or upgraded, which was apparently will not upheld by the learned single judge.
okay, because you are a diploma holder.
I'm a diploma. Then, my lord, we filed the writ appeal. In the writ appeal, my lord, the judgment of the learned single judge was stayed. And it was way back in 23. After a detailed argument, my lord, this order was stayed. It was a lengthy argument. Then, my lord, at one point of time, the division bench was of the view that you should segregate the cases of promoted, those who are promoted and those who are upgraded. That is how, my lord, the second appeal has been filed. The writ appeal number 53 of 25 pertains to, my lord, upgraded assistant executive engineer, and writ appeal number 12 of 22 pertains to promoted assistant executive engineer.
Okay, so in both these cases, the issue is whether a diploma holder can be promoted or not.
Yes,
That's all.
yes,
So we not go into.
Yes, Milord.
It's only the rules.
yes. Now, if your lordship would kindly,
In fact, if your lordship, if I may just, I'm sorry to,
Yes.
the only formulation of law is only on the basis of one issue. That whether the conditions of recruitment can be relaxed. That's the whole issue, your lordship.
Whether the conditions, whether the, okay.
Whether now, your lordship, we know that there is a repeal and saving clause and there is a relaxation clause.
Whether that repeal and saving, whether that there's a relaxation clause.
Yes.
Whether that relaxation clause
First,
can relax.
yes.
Whether it can be, let me formulate my points. You
No,
get
no,
this time to reply. No, how in my appeal, how can he project his case?
Just a minute. He had asked.
I understand his anxiety.
No.
Just understand.
Yes,
He had asked the permission of the court.
yes.
So it's okay. So that is the only thing.
That's the only thing. And secondly, even assuming but not admitting that the power of relaxation is there, whether the relaxation clause was applied in their cases.
Yeah.
My lord, the first point to be decided in this case is the writ petition was filed 16 years belatedly. The first point to be decided is whether the writ petition is maintainable. First point.
Uh-huh. I can do it from my chamber.
Copy দুটো extra আছে না?
Who's the new?
Second file মানে?
Yes.
My lord, what I'll do, though my lord, I have segregated the appeal, but all the documents are available in writ appeal number 12 of 23. Therefore, I'll refer to this, my lord.
Yes.
My lord, we have also filed an additional affidavit bringing on record certain development which had taken place during very my lord. The cadre strength of executive engineer has increased from 8 to 18. And there is an amendment of the rules also. Now that whatever little obscurity was there, that has been blurred, my lord.
Oh, whatever it be. So, no, let us be very clear. Do you all want to hear this matter or what do you want to do?
No, my lord, the affidavit can be called for in the meantime, my lord. Let's been hear it. There's no difficulty. Slip to be there. My lord, that can be called for also in the meantime, my lord.
Affidavit.
Yes.
Oh, but then how does that matter? Why should
The
that?
cadre strength has increased, but there is a direction by the Central Pollution Control Board also regarding filling up of the post.
But the rules remain the same.
No, my lord, now everybody is an assistant executive engineer. Eventually, the issue boils down to who is senior. And even his client has also been promoted. Now, eventually, it will boil down to who is senior in the grade of assistant executive engineer for further promotion to the grade of executive.
If I may just say one thing, Your Lordship, we all know the law is well settled. I'm sorry to interrupt once again. The vacancy which occurred during the existence of the unamended rule, it has to be filled up in terms of that.
No.
No, yes, no, the vacancy arose that day, Your Lordship. The
No,
promotion-
that law is no longer holding the field.
That is a wrong.
Overruled. Rangaya overruled.
No, Ranga has been interpreted, Your Lordship, in 2023. What it says, Your Lordship, in 2020, the promotion was conducted.
Held to be bad law. That is Lalit's judgment.
My lord,
Yes, Your Lordship.
my lord, now the law is whatever law is prevailing on the date of consideration, that should prevail.
So the
And
consider-
Rangaya said the law which was prevailing when the vacancy arose.
Your Lordship, the promotion was conducted in 2020. So it should be in terms of the rules that were there at that moment of time.
Correct.
Now, they cannot bring the new laws and say that.
No,
it
you
should have
see,
been-
if the motion was held,
Yes,
at the time a certain rule was in force,
yes,
then that's all.
yes, sir, that's it. Your Lordship.
What are you talking about, Ranga, then? That, you know,
What I'm trying to say is that my respected senior is talking of the amendment rules, Your Lordship, which took place in 2020.
I never say,
That will not help them, Your Lordship. in
well, I
this case.
never made any argument regarding amended rule. All that I said was, in the meantime, rule has been amended and the
Rangaya
cadre
has
strength
been
has been
overruled,
increased.
that's
Yes, yes.
Yes, yes, Your Lordship.
Now, my lord, my first point is there is delay of 16 years. Now, we were first upgraded in 2005, my lord,
upgraded from which to where?
as assistant engineer. From junior engineer.
Promoted, upgraded.
Yes. In terms of the policy of the Millard, central.
I still don't understand.
No, Lordship will get it. Lordship will kindly take the paper book, Millard.
This upgradation. I can understand upgradation of a post.
With the incumbents.
Upgradation of a.
Yes, yes.
But how do you upgrade a person?
No, there's a statute, enabling statute is there, Millard.
Statute is there.
Yes.
Okay,
Millard-
supposing there was no statute, there's no question of, there's no question of.
Certain. In fact, Millard, promotion, upgradation, these are all regulated by some rule or some executive instruction. Without there being a rule or an executive instruction, nobody can seek any benefit. Now, if your lordship should kindly come to page 247, Millard. That's
Of the
two
written
forty-seven
certificate.
of the first writ appeal,
Oh,
12 of 23. Lordship will kindly take the first one where all the documents are there.
joint. It's all joint. See, there's going to be a problem turning these pages.
দুটা কি করলি? কি করলি?
Why have they all joined,
I don't know, Mila.
why are they all? 247. No, it's not that, but see, all this and all. Yeah, we made knife.
Unnecessarily.
It becomes very difficult to take the pages. I've got some loose.
Well, everybody has got his own way of handling, files.
Tight with this. Right. Yes,
Please come to page 247.
yes.
Minutes of 75th board meeting held on 19th of June 2001 in the office chamber of Chairman Pollution Control Board, Assam. Now, Milord will kindly come to page number 251. Upgradation of the post of junior engineer to assistant engineer as per Central Pollution Control Board norm. The member secretary apprised the board that as per Central Pollution Control Board, no diploma engineers should be recruited and existing diploma engineers should be upgraded from the post of junior engineer to assistant engineer, aiming at increasing efficiency of the engineering service of the board in future. Central Pollution Control Board also desired the state boards to follow the said policy. The matter was discussed. The board agreed to the policy in principle, but considering the present financial position of the board, it is resolved to upgrade this post of junior engineers, which they have confirmed eligibility of norm phase-wise. Now, board will not fill the present or vacant post of assistant engineer till it is decided by the board otherwise. Member secretary of the board will submit service sheets of the upgraded engineers person-wise, specifically mentioning the period of qualifying service, scale of pay, basic pay, departmental procedure, if any, of the junior engineer for final approval of the board. So this was there was a directive from the Central Pollution Control Board that all the diploma engineers should be upgraded. And the idea was the administrative exigency of increasing the efficiency of the engineering service. And further decision was taken not to make any recruitment to the post of the assistant engineer. Pursuant to this decision,
Now,
and now if a lordship would kindly come to page 147, Milord.
yes,
Page 147, Milord. Yes. Under Rule 20, actually it should be Section 22A of the Water Prevention Control of Pollution, Assam and Assam Rule of 77, as amended, the following 14 junior engineers of this board, having experience of more than 10 years of service, are upgraded to the post of assistant engineer with immediate effect.
so they are diploma holders.
All are diploma holders. All are diploma holders.
Now, what is the rules?
Yes.
At that time?
Now I'm placing that. Yes. Copy my lord, that was there. Whether it is still there, I don't know. This matter was heard extensively, my lord. This, my lord, Pollution Control Board employs regulation. I think so, yes.
Anyway, what does it say?
Yes.
How do you fill up the post of AE?
Yes, I'm coming.
I don't have. it.
No, no, এখন নহয় নেকি?
No, it's okay, I will, okay.
Has your lordships got that regulation of 12 Miller?
Yes,
Yes. Yes. Please come to page number 3.
it,
Yes. Gather 4.
yes,
I'll have your lordship's kind attention to 3. The board may by resolution may upgrade or downgrade post within the sanctioned strength. However, any addition to the existing strength of the cadre shall be with the approval of the government of Assam. So this is the enabling provision, my lord. Then my lord will kindly come to 7 at page number 6. Method of recruitment at 7, my lord, at page 6. Please come to Roman 4, clause 4. The number of vacancies under various cadres and their percentage for direct recruitment and for promotion from the next cadre shall be decided by the board authority. Then my lord will kindly come to Roman rule 9 at page 8. Recruitment and promotion. Now please come to 9.2, my lord, at page 9. Qualification, experience and promotion of employees under engineering and technical service.
yeah,
For recruitment to the cadre of assistant engineer in the board, the required qualification would be bachelor's degree in engineering, that is BE, BA Tech, BSc engineering, so and so, so and so, so and so, or environmental from any recognized Indian or foreign university. The educational qualification and experience for other posts under the services shall be as per table 2 in appendix 2. I'll come to this appendix 2, my lord. It is at 33. Promotion from the level of assistant engineer to executive engineer and then to EE shall be on time scale basis, subject to availability of the post, suitability of the. That means up to assistant engineer, my lord, it is on the basis of seniority. Then, according to C, my lord, from executive engineer and above, it will be a selection
yeah, bachelor's degree is a requirement.
requirement, which we are not. Yes. Now we are upgraded. Now, my lord will kindly come to.
How can you be upgraded in violation of the rules?
My lord,
How can you be upgraded in violation of this regulation?
it has been done because of the policy where the rules permits. Now, please come to
No, no,
page
that is the rule permit,
No, so we'll kindly come to page 33. That there lies the answer.
page 33.
Yes.
Okay.
Everything hinges on this particular paragraph. Now, please come to appendix 2, my lord.
Yes.
Statement showing cadre-wise service criteria for initial recruitment and promotion. Now,
Yes.
please come to serial number 4, my lord.
Yes. Serial number,
4 is the executive engineer.
okay.
Now, please come to extreme right-hand side column remark.
Yes.
For existing promotee engineers, qualification shall be relaxed to diploma in engineering.
Maybe. Okay.
Am I clear, my lord?
That is for EE.
Now please come to 5.
5, yeah. Do.
Assistant executive engineer.
Hmm. Hmm.
Same thing.
Hmm.
So we were diploma engineers. We were upgraded in the year 2005. Nobody has challenged that, my lord. The gradation list is not under challenge. Now, entire case hinges on one aspect, my lord, subject to what your lordships may say. This,
6.
no, my lord, 5, serial number 5.
But your entry
Huh.
is on 6.
Yes.
Your entry is on the base of 6 as AE.
No, no. I was a diploma engineer.
Correct.
I was upgraded in 2005.
Correct.
That has attained finality. I'm a diploma. I'm a assistant engineer. for recruitment of assistant engineer, there is a requirement of BSc, but it was dispensed with. It was relaxed by invoking regulation 69 through 49.
Where is,
Now that is, yes,
where is that?
yes. Please come to page number 31.
Yeah.
Where the board is satisfied that the operation of any conditions under this regulation causes undue hardship in this particular case, the board may by order to dispense with or relax the requirement of that regulation to such an extent and subject to such condition as board may consider fit and proper for dealing with the case in a just and equitable manner by the board resolution. Now, my lord will kindly see, I attained the stage of executive engineer in assistant engineer in the year 2005. That has never put to challenge. That has attained finality. Now there is a provision in the rules as far as promoting engineers are concerned, the requirement
So
of
that AE has never been put to challenge. Now the issue is with regard to
now as
AE
then
to AE.
because I have achieved the position of AE, now whether I am entitled to further progression in career. Because even for executive engineer also, it says for promoted diploma engineers, that requirement of B is not.
In the single, before the single judge,
Yes.
was it put to challenge your AR
No.
to AE?
No.
So that has attained final.
That has attained finally. That is my case. You know, that's why I say this appendix 2 is very important.
So this appendix 2,
My humble
under appendix 2, you are entitled to be.
yes, because now I have to be treated. My humble submission is, my lord, for existing promotee, there the word promotee has.
Just your order
Yes.
to AE.
Yes. Yes. That order, promotion order, my lord will get it at page number 114, my lord. Page 109, my lord, the minutes. Page 109.
Yes.
Promotion of assistant engineer to assistant executive engineer.
Yes.
There are 3 vacant posts in the cadre of assistant executive engineer and 3 resultant vacant posts of assistant executive engineer will occur consequent upon promotion of assistant executive engineer to executive engineer. This 6 number of posts are to be filled up by promotion from immediate lower cadre of assistant engineer as per the Pollution Control Board Assam rules and so. The 3 ACRs for the post are placed below for the selection committee. Then below will kindly see the second subpara. After consideration of the educational qualification, experience and ACRs, the committee recommends for promotion of the following assistant engineer to the rank of assistant executive engineer for position 12th and 17 respectively, Dhiren Sharma and Jayanto Ulodhipoti.
These are the appellants.
These are, yes, appellants. Appellant number.
In which case?
In this case only, appellant 1 and 2, my lord. These 1 and 2 are 1 and 2, and the other are 3, 4, and 5. Now, these are the against existing vacancy.
In this appeal 12, how
Ah.
many appellants are there?
Initially, it was 10, my lord. Now it is 5. This 5.
Okay. Okay.
And this Benudhar has retired, my lord. Now, those 2 are promoted against existing vacancies, and in the resultant vacancies, these 3. For the resultant vacancy against the roster point number 1, 1st, 5th, and 8th, in the roster registered, appointing authority has placed ACRs of eligible incumbents. The selection committee members have gone through the ACRs of the incumbent and recommends following assistant engineer to the rank of assistant executive engineer for position of 1st, 5th, and 8th after issue of office notification and joining of Sri so-and-so, so-and-so. So Benudhar Talukdar, he has retired, my lord, in the meantime. Mr. Pathak Chandra Boro and Aurobindo Das. So this was the minus of the DPC. Then, my lord, the promotion order is at page number 114 and 115. As per recommendation of the selection committee meeting held on so and so, Dhiren Sharma, assistant engineer, is promoted to the rank of assistant executive engineer until further orders in the pay scale of so and so. So Dhiren Sharma is appellant number 1, Jayanto Kolodipati is appellant number 2, Benudhar Talukdar is appellant number 3, Pathak Chandra Boro is appellant number 4, and Aurobindo Das is the next page, Miller. These are the promotions.
Okay, so accordingly, so you have said that because of that, since you have already, your appointment as AE has become
Final.
final.
Ah,
But you see, when you look at page 33 again,
33.
technique 2,
Yes, Miller.
when you look at the remarks,
Yes. Existing promotee engineer.
yes, you are not a promotee.
Therefore, my submission is, Miller, in the expression promotee, upgrade has also to be included. Otherwise, Miller, it makes no sense, Miller.
That is why.
See,
Yeah.
in service law, it all depends upon the facts of each case. We cannot put everything into a straitjacket formula. Now, kindly similar, number 1, there is a factor of delay. Our upgradation was in the year 2005. And the challenge was laid only in 2016, 19? 2021, na?
Just a minute.
21.
So just a minute. This 114, what does it say? Does it say promotee or upgradation?
No, Millard, here in respect of 1 to 5, it is promotion. I'm a promotee. As far as 1 to 5 is concerned, Miller, there is no difficulty, they are promoting. This argument will hold good for 6 to 10.
So for you,
As far as Miller,
you are
I'm a promotee. 1 to 5 are promotee.
okay. The assistant engineer,
Yes.
I think the source of recruitment is only direct recruitment.
No, there is a promotional quota also.
What your quota?
Yes, that's why, Miller, this provision.
No, so for AE there's a promotional quota.
Yes, kiman percent? No, earlier this junior engineer post was there. Now, because of the decision of the Central Pollution Control Board, now the entire post of junior engineer has been done away with. Now, Miller,
Maybe, but
initially it was there.
so when they saw these rules, whereby a certain quota was kept for promotees for diploma.
Yes.
When was that done away with?
That 2000, Miller, that I have read that resolution, Central Pollution Control Board decision.
2000 it was.
Yes. 2012, Miller, regulation came in 2012. Prior to this, there is another set of rules.
You see, because in 2005, you were upgraded, no?
Yes. From diploma engineer to
You were not promoted.
we are not promoted. But by whatever means, Miller, we reach this stage of assistant engineer. And upgradation is a mode which is recognized by the statute. Regulation 4. And this part is there under the Central Act also, Miller. Under the Central Act, if your lordship is kind. Promotion. এটা হলো নাম করতে করেছে আর হ্যাঁ
Number 4.
Regulation is of 2012. Yeah.
May I just point out one thing, Your Lordship? In 2012, Water Prevention and Control of Pollution Rules, Assam, 1977. They were upgraded in terms of these rules, but these rules does not envisage for upgradation. In fact, under section 22, if Your
That
Lordship,
is not on the challenge.
no, yes, Your Lordship, but that is not required to be under challenge because in 2012, new rules came. So whatever promotions, whatever appointments has to be done in terms of the rules of 2012. So this 2012 rules was given a go by.
2002,
May-
promotion to AE.
Yes, Your Lordship.
What is the requirement for?
No, no, their own, no, their, as far as they are concerned, my lord, please come to the.
No, just a minute.
Now, just to understand their case.
No, no, I'm just.
To understand your case.
Yes, yes, yes.
You are now,
We were diploma engineer.
your diploma engineer, you've been upgraded rightly or wrongly as AE. Now in 2005, that has attained final.
Right,
Now with the coming of the new regulation.
yes,
There is no change to their position. They continue to be AE.
yes, Your Lordship.
Now why can't they be promoted to AE?
Because, Your Lordship, the rule does not provide, Your Lordship.
Which rule does not provide?
This rules does not. provide.
2012,
Yes, Your Lordship.
where?
If I may just point out.
That's why I'm trying to bring their case, para 23 and 24 of the writ petition, my lord, their case. Their pleaded case in the writ petition. If your lordship would kindly come to. Yes. Sorry, my lord, page number 69. This is their case. Para 24. That the petitioners respectfully beg to state that regulation 9(1) governs the manner in which promotion has to be made to the higher cadre, and accordingly appendix 2 table 2 provides that all posts of assistant executive engineer are to be filled up by promotion 100%. It further stipulates that one has to have 5 years of service in the feather cadre of assistant engineer for being eligible to be considered for promotion. Now, this is the line. It categorically stipulates that one must possess the qualification of BE, BTech, AMI, etc., for being eligible for promotion. However, the qualifications shall be relaxed to diploma engineers in case of incumbents are or have been promoted in the said feather cadre and not otherwise. Their only case is, my lord, we fulfill the other criteria. We do
But
not
you
have
were
this the degree. We do not have that BE, BTech or etc. or AMI. Now, my lord, by virtue of the decision, we already stand upgraded. Now, that position has not been challenged by anybody, including the present writ petitioner respondent. However, despite that, his case is because we do not have BTech, BE or etc., we cannot be promoted under regulation of 2012. That is their only case. An answer to that is, my lord, we must get the benefit. Now, as far as the promote is concerned, there is no difficulty. As far as appellant number 1 to 5 is concerned, there is no difficulty. Because this view has been expressed by 2 former division bench, my lord. That's why division bench was of the view that these matters should be segregated. In fact, during the long course of hearing, my lord, this honorable court was of the view that no, we'd like to deal with these two separately. That is how, my lord, for the upgraded, we file the subsequent appeal. Now, as far as the promote is concerned, we are covered by appendix 2, that's serial number 5. Because since we have to be treated as we are promotee, therefore, for that, they cannot insist on that qualification. Now, my only hurdle is perhaps the upgraded ones. There, my submission is, my lord, that we should be also treated as an promotee because rightly or wrongly, because of the decision, because of the administrative exigency, we have been, my lord, brought in, upgraded as assistant engineer.
So you're talking about, so the updated ones are in, the.
Second appeal, my lord. Second appeal. No, not 12. Second one, my lord. No, I cannot say.
No, in 12, I think.
Even so, ma.
Upgradation is in.
Upgraded is writ appeal 53.
Item number 4.
Upgradation is 53.
53, second item, my lord. There are 4 and 5. Lordship is having the file of 4, that is the first appeal. There is absolutely no difficulty. My learned friend was present. This matter was heard by 2 division benches, my lord, 2 former chief justices. Everybody, after a lot of discussion, this stay order was granted. Only thing is, my lord, what would be
I
the
don't think
fate
it
of
was
the...
so easy. If it was so easy, it would have been disposed of.
No, my lord. No, my lord.
No views was expressed, your lordship. No, they were on interim order. No view, such views was expressed. Has been stated by my respected senior.
My lord, this division, the honorable division bench, the predecessor division bench was of the view, my lord, that since one class is promotee and one class is upgradation, therefore please, separate it. And now our lordship has seen, as far as the promotees are concerned, so there is no difficulty because as a promotee, the diploma is good enough. Kindly come to that thing once again, my lord.
No, but what about this educational qualification?
No, that no.
There
Kindly
would be
see,
a-
my lord. No. For existing promotee engineers, qualifications shall be relaxed to diploma.
Correct. So that's for promoting, there's no problem. Gone.
So that is not difficult. Now the question is regarding upgraded ones. How to treat the claim of the upgraded ones? That's the only question. Now my humble submission is, my lord, by this same action, the promotees and upgraders were upgraded as assistant engineer. And that order has attained finality. I having reached that stage, now like, will it be equitable to say no? Now onwards you cannot move up because you do not have a degree.
Yeah, upgradation was the challenge.
No.
You see, the upgradation could have been.
My lord, there are case laws on this point, my lord.
What was the law? What was the rules prior to this 2012 regulation with regard to upgradation?
There was, my lord, this, if your lordship would kindly have this Water Act, my lord, please have this. Ashe, second.
22.
22.
If your lordship turns to page 10, the rule, provision of rule 22 is there in the copy which I have submitted. They are upgraded in terms of these rules, but this rules also says promotion. This rule does not envisage for any upgradation.
But it has been done.
That is not on the challenge. That is not required, in fact, your lordship. Well satisfied.
My lord will kindly come to rule 22, my lord. Page number 7. The chairman shall have overall control over the functions of the activities of the board. Chairman may undertake action not concerned. Please come to Roman 3, my lord. Subject to rules, if any, made under subsection 3 of section 12, the chairman shall have full powers in matters of appointment, promotion, confirmation, transfer, confirmation, transfer, disciplinary proceeding, termination of service of the officers and employees of the board. So, my lord, if there are rules, it's well and good. If there are no rules, then power of the chairman would be plenary. And my lord, merely because here the expression upgradation is not there, I don't think, my lord, the rules of interpretation of statute would permit that argument to hold, my lord. Because these are all illustrative. Anything to do with condition of service, my lord, the power has been conferred upon the chairman. Of course, there is a rider, it must be subject to the rules. So as long as there is no rules, the chairman has got, my lord, plenary power.
Where is the subsection 3 of 12?
Yes,
Okay, it is there.
it is there, my lord. Well, see to go there. Okay.
Yes, so you were saying which page? 22.
Yeah, the same rule which my respected senior has read just now. He has already read, your lordship.
Now, my lord, just to formulate my points, my lord. So, lordship has seen the facts. One set, promoted, one said upgraded.
Before that,
Yes,
now the learned single judge has allowed his writ petition.
yes.
On what ground?
On the ground that, my lord, we do not have the degree.
Okay, then.
That's the only. So we could not have been considered even for, my lord, a year.
It did not go into the issue of your 2005.
No. That's why my first point is this writ petition was filed in 2021 after a delay of 16 years. Number two, my lord. Number two, right to be considered for promotion is a right, not right to promotion. He was not even in the, my lord.
Anyway, that is a-
Anyway.
that's a-
Now
So now you'll have to make the correlation between promotion and
Mala, upgradation has, Mala, I'll place few case laws on this point, Mila. Just to,
basically, I don't understand this upgradation. How can you? I mean, you can upgrade a force.
yes,
That is there.
yes, Your Lordship.
But the question of upgradation of an individual.
No, Milord will kindly come to the decision. No,
Unless it amounts to promotion, it cannot.
No, Milord will kindly come to the decision to upgrade. That is, Lordships will get it. Meeting. Yes, page number, Milord, 141. Lordship has seen the decision regarding promotion. Now the decision of the board regarding upgradation is at 141, Milord. Page 141.
Upgradation.
Yes. It starts at 141. Please come to 142.
Yes.
Agenda item number 3.
Yes.
Proposal for upgradation of the following post. Assistant Executive Engineer post to Executive Engineer. Assistant Executive Environment Scientist to the post of Executive Environment Scientist. Assistant Engineer to the post of Executive Engineer. The chairman had informed the board that members of most of the officers has completed more than 26 years of service in PCBA, and since there is less number of vacant promotional posts, the board may upgrade the post to boost up the morale of the employee. The member secretary also stated that upgradation may be done as per the following manner. Now please come to C, Miller. From assistant engineer to assistant engineer. 10 years of minimum of total service as assistant engineer in the board. After thorough deliberation, 13 number of assistant executive engineer may be upgraded to executive engineer. 2 number of assistant executive environment scientists may be upgraded to executive environment scientists. And now regarding the appellants. And 5 number of assistant engineers may be upgraded to assistant executive engineer, keeping the cadre strength as 264 number as revised on 2013-14. This upgraded post will automatically come to the original cadre upon retirement, termination, resignation of the above mentioned post. The board member has agreed to upgrade this post under section 4.3, chapter 2 of PCB. However, an intimation may be sent to the state government. So, my lord, there was an decision within the cadre strength to do it. And as required, the proposal was sent to the government also. And it has been approved also. So therefore, it cannot be said, my lord, that the action do not have the legal sanction. My lord, yes, there is a distinction between promotion and upgradation. There is no difficulty about it. In service jurisprudence, there is distinction. Normally, what happens, my lord, when there is a stagnation, then what is ACP, my lord? It's an upgradation only. You will work in the upgraded post. You will get the salary also. By the time he gets his regular promotion, he will earn the promotion from that day. Otherwise, for all practical purpose, an upgraded employee continues to enjoy the same benefit. So, my lord, having regard to this, can't we say these may be irregular, but these are not illegal, my lord? Max, we can say that having regard to what we normally understand in service jurisprudence, this could be an irregular, but this is not an illegal act. This is something which is permitted by the regulation. And what about the delay of 16 years, my lord? If they're so vigilant, they should have come immediately. Then how come people are not having a degree? You are upgrading them. Now, if that's why Supreme Court said, my lord, in some of the cases, equity.
So out here, you have been upgraded
Yes.
from AE to AE.
Yes. I was upgraded also as AE.
So upgraded. They're changing what about the cadre strength?
Cadre strength is same, remains the same within that cadre strength. 264.
Within the cadre strength, but
Only thing is, my lord, when we retire,
it will
then
go back.
It's something like a supernumerary post.
So the cadre strength in each grade will change.
No, my lord, my only submission is, your lordship is also a court of equity. Now, Supreme Court in Ashok Sharma's case said, my lord, equity knows no halfways. In the sense, the fact that I have become AE, so equity demands I should also become AE. I should also become executive engineer if otherwise, my lord, it is permissible. Can I place 2-3 judgments on this point?
Just a minute. You became AE on upgradation.
Yes. And also AEE on upgradation. As far as appellant number, appellants in the second case, 53.
But there is no. Okay, you became AE on this.
2005, same, my lord. There are 10 appellants before your lordships. In writ appeal number 12 of 23, there are 5 appellants. Initially, in fact, 10, my lord, now 5. They're upgraded as AE, promoted as AEE. In writ appeal number 53, they were not only upgraded as AE, they were also upgraded as assistant executive.
In item 12, they were promoted
Yes.
as AE and then promoted as AE. That is now fine because of the
Language.
next year.
Ah.
The language used there. Because diploma is there. But with regard to upgradation,
Yes.
upgradation has been done.
Yes.
Upgradation as AE not under challenge.
Yes.
So that remains.
That's it.
Now whether that
Now,
upgradation.
my lord, I'll place 2-3 case laws, my lord. First of all, my lord.
Can be done because
Yes.
because it will be against appendix 2.
My lord.
It would be against appendix 2.
No, there my humble submission is, my lord. My humble submission would be, lordship will read appendix 2 to include promotee, the upgraded ones also as promoters in the circumstances of the case. Well, I am as a lawyer, my lord, I can only possibly, my lord, subject to.
I'm trying to understand.
Yes.
There's a point.
My lord, what I.
Upgradation of post, that portion is not a point.
Yes.
Upgradation of the person, that is.
No, I'll place case laws on those points. Yes, yes. It's condition. Written. If your lordship should have a Union of India versus Pusparani, এখন ডিরেকশন 2008-9 SCC 242 যোৱাবাৰ সব দিয়া আছিলে তাতে আছে নেকি সাইটেশনটা প্রথমত এইটো দিয়ক 2001 3SCC 125
So many documents. Yes, anything to do with that promotory also is challenging.
Yes, your lordship. In fact, the rules does not say, it says for the existing promoter, but they were upgraded. They are not the existing promoter.
No, but this W812, they were promoting.
No, your lordship.
Everyone was upgraded.
Yes.
No, initially, secondly promoted. From AE to AE promoted.
Initially upgraded.
Yes, and that appendix say for the existing promoters.
No, my lord, if
they
that
were
is-
upgraded, they
If
are not
that is, if
promoted.
that
I'm
is not
satisfied, Your
challenged,
Lordship.
no, question is, if that is not challenged, whether they can make this even argument.
I was not
That
born in the
2005
country.
upgradation, when it is not under challenge, can this argument is maintainable, my lord?
Yes,
No, I understand. Okay. So they were not promoted at any time to AE.
no.
They were upgraded to
Yes,
AE.
your lordship.
Yes.
So whether the upgradation can be said to be a promotion.
Yes,
So according to you,
it's no.
that upgradation cannot be said to be a promotion,
Correct.
while you are saying that that upgradation means promotion.
Yes. And your lordship, that Supreme Court judgments has categorically stated what is upgradation and promotion.
Be a long and short of it.
Yes, your
No,
lordship.
my lord, there is no dispute that there is a distinction between promotion and upgradation. But in the facts of this case, whether the general principles will apply or lordships would like to carve out an exception. That's the only point.
I will see.
Yes. Now please have the judgment, my lord, 2001 3SCC 125.
Where is this? He has not given a copy.
কি মুৰা কৰি আছে ৰাতিপুৱাৰ পৰা? কি জানো মই আগৰ পৰাটো কৰিছো এইবিলাকে আছে। Nowadays is very difficult, Miller. The book lists are not given.
আপুনি জাজমেন্টটো ৰেফাৰ কৰি আছে, এই জাজমেন্টটো ইয়াতো ৰেফাৰ কৰিছে, আপুনি ইয়াৰ পৰাও পঢ়িব পাৰে ভাৰত চেঞ্চৰ।
No, মই এইটো কৰা নাই।
It's my written submission, your lordship. But what my respected senior is going to refer, that judgment is also there.
Well, this is a direct judgment on upgradation. Let us see what's Supreme Court. 2001 3SCC 125. It was a case of judiciary only.
What does it say?
Yes. My lord, it says the upgraded ones will get the benefit.
Benefit of promotion.
Yes, my lord, parameter provision like 4-3 were there in this case. Delhi Higher Judiciary case. SN Dhingra versus Union of India.
Same thing.
Yeah,
Also, it is there.
compilation it is there.
Last one.
Yeah.
Please come to Millard, page 127. First part, the facts. We can resume at 2 o'clock, Millard.
So many matters.
Or some other day, Millard. Let the affidavit also come.
But how many? I told you, we went over this. I went for a great time. You were still there. The thing is that we have heard, the other thing, we have heard, I mean, facts is there. How long will you take?
45 minutes.
Public.
Maximum, your lordship, maximum, your lordship.
There's nothing to discuss now, it's only the law.
Yes, your lordship.
Are there.
Yes, your lordship. I'll cut down to 30 as short as possible. I'll place 5-6 judgments, only that much, your lordship.
Why is it there?
And I
On
have to,
conditions
I have
of
to
legal.
reply also. Millard.
Oh, God.
Your lordship, let my respected senior complete today. If it doesn't get complete, you can continue tomorrow also, Your Lordship.
No, no.
No, tomorrow I am not there.
Tomorrow also there's a lot of, we have fixed a lot of matters.
I'm sorry, Your Lordship will fix it as per
In that case, my lordship will have it in the next week.
on Monday.
Next week, not Monday, Thursday, next Thursday.
No, Thursday,
Fixed a lot of matters, no, for next week.
Or then it has to go beyond vacation. Lordship can treat it as a partner, there's no difficulty.
I don't like keeping partner because again, I've got to know all the facts.
In any case, my lordship will be sitting in division bench now often.
I don't know. Once chief comes, then I'll back to criminal. Back to FOXO and 302 and matrimonial appeals.
Those are also required, my lord.
Ha.
Your Lordship, let my respected senior continue.
Time like for judgment very does it.
You see,
It will take about more than half an hour.
Fine. I'll cut short.
you make, okay, you have given all your, you see, why don't
No,
you
Milord.
make a small bullet point
No, my lord, my humble submission is.
with regard to your judgments, not with regard to your the
Lord,
facts. Very
my humble submission is, my lord, as far as the first appeal is concerned, I don't think it is posing any insurmountable difficulty. That's my understanding. But as far as the other one, I have to overcome 2-3 questions. Therefore, it will take some time, my lord. Let us be very clear about it.
Learned single judge, the learned single judge has allowed the writ petition
Yes, whole hog.
only because you did not have you did not have
BSc.
the BSc.
No, Your Lordship,
But-
the upgradation of 2005 was also taken into consideration.
Okay,
Four points are formulated, Your Lordship.
that it was not taken.
No, it was taken, Your Lordship.
No,
My
no,
respected senior was not.
without challenging, how can there be, my lord? No challenge was laid to the 2005.
Late to the
I've
2005.
been maintaining that only. I've never said anything else.
Without challenging that,
Yes.
the single judge has gone into that issue.
Yes.
Your Lordship.
Settled issue of 16 years has been unsettled without there being a challenge.
No. My answer is no, Your Lordship, because there are 25 persons in that cadre. The 10 persons were appointed in 1992, 1993. These peoples, they were upgraded. At that moment of time, this rules does not exist.
Correct.
2012.
Correct,
And I was also not there. I was appointed in 2012.
correct.
So the promotion under 2012 rules came for the first time in 2020, wherein I was not considered and not promoted, and these people who were not qualified as per the rules and the regulations.
So the promotion was done as per the 2012 rules.
Yes, no,
Regulation.
in violation. Yes.
Huh?
Yes,
As per the 2012 regulation, it was done.
yes, Your Lordship.
So as per the 2012 regulation,
Yes. They cannot even be considered for promotion.
Why? Then I should not be an engineer also. Where had learned single judge decided that point? That our upgradation is not under challenge, that we are full-fledged AE. It's a very interesting matter, Miller.
Your Lordship, when the promotion was
no,
undertaken.
again, the entire issue boils down to the correlationship between the words
Miller,
that
Existing
Miller,
upgradation and promotion.
Milord, my humble understanding of the case is, in service matters, Milord, we cannot simply get bogged down by these subtle principles. It all depends upon the facts of each case and end of the day, whether any serious, illegality has been caused to the writ petitioner. That is an aspect. End of the day, whether there is a violation of Article 14 and 16. Question is, if I can become AE, which nobody has challenged, now what would be my status? Supposing, my lord, this promotion I don't get. Am I not AE? Who has questioned that? They never questioned that. Now, having become AE, am I not entitled to further career progression? That's why Supreme Court says, my lord, equity knows no halfways. That's what the proposition in Ashok Kumar Sharma's case.
No, your case out here is basically promotion. What is the difference between the promotion and upgradation?
There is, Miller. I never said there is none. There is. In fact, Miller, Pushparani's case deals with that point. I'll come with that. Pushparani.
That is the main thing.
Yes.
That is the only thing.
Yes.
In upgradation, there are two things. There cannot be any selection, and if there is any element of selection, that will amount to promotion. And secondly, the upgraded employees continues to be in the same feeder post, but they'll enjoy the perks and the avenues of the upgraded post.
Now, my
They
lord,
cannot be.
kindly see, my lord, the self-defeating argument. In a promotion which is based on seniority, where is the requirement of selection? Therefore, my lord, every argument is self-defeating. Kindly see, my lord. Up to executive engineer, it is based on seniority. Yes. Beyond executive engineer, it is selection post. So all that is required is whether I have the qualifying service. I am an assistant engineer, whether I have qualifying service. I have.
You see, if you say that,
Yeah.
now as per the 2012 regulation, he is not a AE. He's a junior engineer. Still an engineer.
Yes, no. The issue was like this. In fact, the rules, these regulations also says those who have been promoted from junior engineers.
Anyway, we'll take it up some other time. I've got a meeting. I've got a meeting at one, but
Sorry.
They could have challenged the rule, which they.
Well, our lordship will keep this matter as a part of, we'll hear the matter after the vacations.
no, I bet I'll hear it again, but not as part of.
Okay.
Otherwise, I'll forget.
And my lord, our additional affidavit may be brought on record.
Yes, obviously.
Okay, right. List the matter after the vacation.
Yes, yes.
On the prayer of the party. The additional affidavit filed by the appellants should be placed on record. Should be put on the.
Deeply obliged.
Oh, we must.
Wait, please. Now, the petitioner was initially appointed as assistant engineer, my lord, by the erstwhile Municipal Administrative Department, Government of Assam. Now, my lord, that was on 5/7/88. Following selection by the Assam Public Service Commission. Thereafter, my lord, on 10/7/89, the appellant was sent on deputation to Urban Sewerage Board. Now, my lord, the long and short of the case is, eventually he retired as chief engineer of the board. Now, the issue is whether I am entitled to regular pension or I am entitled to, my lord, CPF. That is the dispute. Now, if your lordship would kindly come to page number 33, my lord.
Yes.
Now, this is a communication from managing director of the board to the government. With reference to the above, I would like to point out the following matter before the government in connection with absorption of Sri Azizur Rahman, assistant engineer in the board. Rahman was working on part-time basis with effect from 3/7/89 to 9/4/90. During this period, he was drawing his salary from the Director of Municipal Administration. Since 1/4/90, he was taken on deputation to Assam Urban Water Supply and Sewerage Board. He was drawing deputation allowance up to 14/11/95. The government of Assam has intimated the decision to allow absorption of Sri Rahman by letter dated 2016/95. Subsequently, in the 18th meeting of the Board of Directors of the Assam Urban Water Supply and Sewerage Board, held on 17/11/95, the board approved absorption of service of Sri Rahman. In the light of the above facts, and as Sri Rahman took deputation allowance under Foreign Service terms and conditions up to 14/11/95, it was decided to absorb him in the board permanently with effect from 15/11/95. In this regard, we request the government to enlighten us from which that absorption of Raman to the board should be counted. So, my lord, board was of the view that with effect from 15/11/95, he should be absorbed in the board, and therefore they sought the advice of the government. Now, page 34, next page, my lord, reply of the government. This is very important in this case. With reference to a letter on the quoted subject, I am directed to say that Sri Azizur Rahman, Assistant Engineer, should be absorbed substantively in the service of the board, and then the board will appoint him substantively in the board under section 22(2) of Assam Urban Water Supply and Sewerage Board Act 85. The service rendered by in the state government shall have to be treated as service under the board and have enjoyed all the rights, privileges, that is leave, pension, etc., in the same situation as he was enjoyed in the state government employment. I am therefore to say that service of Rahman, assistant engineer, may be treated accordingly with effect from the date of his joining in the government service, that is 5/7/88. Now the government on the contrary said that he should be absorbed under section 26(2)(2)(2), and the effective date should be 5/7/88, and his condition of service should not be changed to his detriment. Now, why the government says so, my lord? There is a purpose. Now, I'll place the act, my lord. Pick it up from this. Now, first, your lordship will kindly come to section 2(1), my lord. Definition of appointed day. Appointed day in relation to any local area means the date of notification related to that local area under section 18. Then, my lord will kindly come to section 18, my lord. Now, they kindly see the heading, my lord. Vesting of existing water supply and sewerage services. State government, for the purpose of public purposes, by notification in the official gazette, declare in respect or any urban area that as from the date to be specified therein. So that will be the appointed date. The idea is, my lord, these services will be taken over. Now, please come to section 22.
Vesting of existing water supply and
Yes.
sewerage service.
My lord, actually what had happened, my lord, when these services are taken over by the board from the local bodies, along with it, my lord, everything will be taken over, including the services. Therefore, we are concerned with section 22, transfer of employees. Section 22. At pages may not tell you, my lord. Save as otherwise provided in section 8. Persons who were either employed in the public health engineering organization of the government of Assam or under a local body exclusively in connection with the urban water supply or sewerage service or sewerage work or sewerage farm shall from the appointed day be transferred to the board and shall hold their office or services therein by the same terms and same remuneration and upon same other terms and conditions, and with the same right and privilege as to pension, gratuity, other matters, as they would have held the same on the day, said day, as if the act had not come into force, as the case may be, the aforesaid water supply, etc., etc. So, my lord, the intention of the legislation is very clear. from the appointed day.
This pertains to transfer of employee.
Yes, my case is also,
Your.
well, a transfer and a transfer and deputation are same, Miller. Miller, transfer by of deputation. Transfer and deputation are same, Supreme Court has said, Miller. Transfer by way of deputation. Malad, there are only one distinction. When it comes to deputation, then you must obtain the consent of the employee. But in case of transfer, it is not required. Otherwise, there is no distinction between deputation and transfer. So, my lord, why I have read section 22(1) is for the purpose that the legislative mandate is with effect from the appointed date. The services of the employees of the local bodies and PHC department or any other body stands transferred to the board on the same terms and conditions, including right to receive pension. Now, my lord will kindly come to subsection 2. Every officer or employee of the state government whose services has been transferred to the board shall intimate the state government in writing within 2 years from the date of transfer of his service to the board that he may be permitted to retire from this service, and thereupon he shall be permitted to retire from the government service, and he will be entitled to compensation, pension, gratuity, and any other benefit permissible to him, maximum possible limit under the rules, or he should be absorbed substantively in the service of the board, and then the board will absorb him substantively in service, and thereupon the service rendered by him under the state government shall be treated as a service rendered under the board. Now, this is important. And he shall be entitled to have such right or to such similar right in the change situation with regard to remuneration, leave, and pension as will not be less favorable to the service condition, agreement, and rise as he would have been entitled to or before him as he was employed in the board. Now, my lord, lordship has noticed from page 34, when the board sought clarification from the government, because I was a government employee, government said, you absorb him under 22(2), and the effective date should be 5/7/88, meaning thereby that he stood absorbed in the board with effect from 5/7/22/88 under 22(2)(2). So 22 clearly brings out, my lord, that I will be entitled to everything, including pension, as if I was not been absorbed in the board. Now, my lord, kindly come to 3. Supposing somebody do not, my lord, exercise the option as contemplated in 2, what is the consequence? If any officer or employee do not give such intimation within the above specified period, it will be deemed that he has opted for being absorbed substantively in the service of the board under the terms and conditions specified by it. Now, my lord will kindly come to page number 34 once again. Hmm. 34, my lord. With reference to your letter on the quoted subject, I am directed to say that Sri Azizur Rahman should be absorbed substantively in the service of the board, and then board will appoint him substantively in the board under 22(2) of the Assam Urban Water Supply and Sewerage Board. The service rendered by him in the state government shall have to be treated as service under the board, and have enjoyed all the rights and privileges, that is leave, pension, in the same situation as he was enjoyed in the state government employment. I am therefore to say that service of the Rahman may be treated accordingly with effect from the date of his joining in the government. So, my lord, government clearly said Now you absorb him under 22(2), and wherever he will get everything as he was getting earlier. Now please come to page 35. Now this is the order issued by the board, my lord, pursuant to the order of the government. In pursuance to the government letter and under section 22, the services of Sri Azizur Rahman, assistant engineer, is hereby absorbed with effect from date of joining in the government service. So the moment it is under 22(2), then I get everything. Now, my lord, what the single judge has done, kindly see me. Single judge has said that I am not a permanent employee, because every government employment, my lord, initially it is said it is officiating or something. Please come to page 83. I would say, my lord, the learned single judge has taken note of certain considerations which are not at all germane. Please come to para 26, page 83. It is nobody's case that, my lord, I'm not entitled to pension under the pension rule of 69. It is not the case of the government. Kindly see, my lord, page 20, para 26. There is no doubt or dispute about the fact that petitioner's service under the board was not pensionable. In other words, board is a non-pensionable establishment within the meaning of Rule 36 of Rules of 69. Therefore, writ petitioner was not entitled to receive pension for the service rendered under the board. Since writ petitioner is not holding a permanent post under the government, nor did he fulfill the requisite length of qualifying service of the receipt of the pension under the rules of 69 as on the date of his permanent absorption under the board, hence he has also not acquired. Lord, I was absorbed with effect from 5788. On that day, my lord, I never had any qualifying service. Can you see me, Lord? Is it the case of the government in their affidavit? Well, where is the question of I being a permanent or a non-permanent employee? I am a permanent employee. I was selected by the APSC, following which I was appointed. Then, my lord, will kindly see, as such, this court is of the opinion that section 22(2) of the Act would be of no avail to the writ petitioner insofar as his claim to receive pension as a government servant is concerned. There is another aspect of the matter which deserves special consideration by this court. It is an admitted position of fact that ever since his substantive absorption in the service of the board, the petitioner has been making CPF contribution. CPF contribution becomes applicable in those cases where no pension is payable to the employee. Upon his retirement, the writ petitioner has also received withdrawn CPF without raising any protest. Therefore, it is evident that since his date of absorption in service of the board, that is 28/96, till his retirement from service on attaining age of superannuation on 31/23, writ petitioner has continued to submit himself to the CPF scheme, being fully conscious and having clear understanding of the fact that he was in a non-pensionable service. It was only after his retirement from service, after the lapse of nearly 27 years since the date of his permanent absorption in the service of the board, that the petitioner has approached this court by filing the present writ petition, asserting his right to receive pension. Such a right of the petitioner, in the opinion of the court, cannot be recognized at this point of time. So, end of the day, my lord, learned single judge was of the view that my claim was belated claim. Now, my lord, my humble submission is very simple. When my absorption in the board was under section 22(2)(2), which is an admitted position on all count, can I be denied pension? Well, I retired in 2023 and I filed the petition in 2024. Where is the delay, my lord? Well, end of the day, pension is not a bounty.
No, that's all right. It's a continuing right anyway.
Yes, continuing, absolutely correct.
So, no, the issue is whether you are a temporary employee or.
No, my lord.
Regular.
Anyway, my lord, my kindly see my selection and appointment, my lord. How can I be a temporary employee, my lord? Kindly see page 29. Please come to the second portion, my lord.
Yes.
Consequent upon withdrawal of appointment of Sri Mojibur Rahman Pradhani and on recommendation of the Assam Public Service Commission by their letter dated so and so, Governor of Assam is pleased to appoint the following person temporarily to officiate as assistant engineer under the Directorate of Municipal Administration. But not every government appointment is of this line, my lord. No matter, my lord, I am selected by APSC.
To officiate.
Yes, they'll say like that, my lord. Every appointment, my lord.
Then come to the next appointment is purely temporary
Yes,
and maybe terminate.
maybe terminate.
Then
But lord, once I am recommended by the Public Service Commission, where is the scope for all this, my lord? I am not a 3F employee, my lord. I was regularly selected by the Public Service Commission. And there is a specific government in the page 80, my lord, in the order also the learned single judge has noted. Page 80, if your lordship would come, my lord. In the present case, para 19, page 80, in the present case, writ petitioner was appointed as an assistant engineer civil under MAD
what
temporary.
is MAD?
Para 19, page 80, my lord.
MAD, what is MAD?
Municipal Administration Department. Earlier it was Municipal Administration Department. On an officiating basis, right, as noted above, there is nothing on record to show that the service of the petitioner was ever made permanent on any date prior to his substantive absorption in the service of the board. My lord, can we conceive of a situation, a 3F appointee being absorbed or permanently sent to deputation in another department, my lord? Is it possible?
I don't know. And everything is possible, I believe.
My lord, I retired as chief. I retired as chief engineer, my lord.
Maybe. I don't know.
No, my lord, the learned single judge has approached the case from an absolutely wrong premise, my lord, in my humble submission. Here the case is whether section 22 to benefit I should get or not. But there the learned single judge's view is this is not relevant for deciding the case. Then how pension rule is relevant for deciding this case? Whose case is it? That I have not served the qualifying service, therefore I am not entitled to pension. Whose case is it, my lord? It's a very simple case, my lord. End of the day, my lord, it's pension. I'm not asking for promotion. I'm not asking for some.
See, can a temporary servant,
Ah,
government servant,
yes.
is he eligible for pension?
No, my lord. Yes. Under government servants, Assam government circular, yes.
Let us see the pension rules.
Yes.
See
No,
that.
my lord, there is circular. Assam government circulars are there, my lord, whosoever has put in 10, 20 years of temporary service also. That's not my case. That's why I'm not brought those pleadings.
No,
I'm
no.
not an employee.
Because you see, there is nothing to show out here that you have been made permanent or regular.
No, my lord, I'm just visualizing one situation, my lord. Is there any instance where a temporary employee is being deputed to another department, where after so many communications between the department?
I don't know. We'll ask.
No, well, I'm just posing that question. And as a temporary employee, I am sent on deputation, and in the borrowing department, well, I retire as a chief engineer. Will somebody not raise this question? And how come, at least the person who were in the zone of concern, they would have said, how come you are promoting him? He's not even a permanent employee. It's not done, Miller. That's not. I think, Miller, the learned single judge has approached this case from an absolutely wrong premise. It is nobody's case. There's no issue of Miller bringing in pension rule here.
No, you see, prima facie, there does not appear to be much error in the judgment. But the thing is that there is a gap.
Yeah.
That has to be explained.
My lord, in fact, we have also filed an IA to make APSCN party to say whether I was selected or not. I made that, I filed.
Was it on the basis of any advertisement?
Yes. Yes.
Where is the advertisement?
Advertisement of someone? That's why, my lord, we have filed an IA to make APSC a party. If that is the issue, because since that issue has been racked up by the learned single judge, we have filed an IA.
Anyway, so now let us hear, I don't know what do you want to do? What do you want to do? You want to carry on with the case or you want to pursue that IA?
No, my lord, if that is the issue, I think APSC is the best person to say whether I was selected or not, whether there was an advertisement or not.
Don't know at this stage.
No,
Because
my lord,
I don't want to hear and then adjourn the matter.
No, my lord. No, my humble submission is if that is the issue, if that is the lurking doubt in the mind of the honorable court, then might as well lordship will hear the Public Service Commission. Then they will say whether there was an advertisement, whether this letter at page 29 is correct or not.
And this was of 1988.
Yes.
There's
No,
no record.
they will have. There's nothing like it.
I don't think.
No,
I
no.
don't think. Anyway,
Once
let
your
us-
lordships, no, once your lordships call for, they will certainly
anyway,
produce it.
let us hear. Let us,
Hmm.
on the basis of what is here.
Lordship, I am appearing for response number 2 and 3. We filed this affidavit and clarifying the entire aspect of the matter for the urban board lordship, water supply sewerage board lordship, 2 and 3. He was on deputation on that particular board
He has a
lordship.
deputation to you.
Exactly, lordship. And we filed that affidavit.
Was he a temporary employee?
Exactly, lordship. That aspect of the matter has been clarified in the learned single judge has dealt with the objection that was raised by the respondents in the affidavit in opposition. That has been very specifically and clearly mentioned in this particular judgment, lordship.
Okay, let us.
Just referring to page number 79, but which my learned senior friend has not referred to. This is a page number, paragraph number 15. Paragraph number 15.
One second, my lord. If your lordship would kindly have this IA 2406. 1 second, my lord. If your lordship would kindly come to page 9. There's an order dated 5th of March 25. In fact, there was some doubt in the mind of the court. Therefore, my lord, this order was passed. On the next date fixed, see so-and-so additional senior government advocate to obtain specific instruction and apprise this course as to why the service of it is not regularized by the parent department. But this information never came.
So that question remains, lordship, because the service was never been regularized in the parent department. So that is the objection.
So where, which para? 15.
Paragraph 15, lordship, in page number 79.
He was absorbed when?
He was absorbed
My lord, I was appointed on
5788.
No. I was appointed on 5788. Then on 10789, I was sent on deputation to the board.
It is there, lordship, in page number 79.
Eventually, pursuant to the order at page 35, I was absorbed with effect from my initial date, that is 5788.
88.
Absorbed when?
5788.
No,
With effect.
57, that is with effect.
Ah.
The date of absorption.
Date of absorption, page number 35.
Date.
Yes, I'm just giving the date.
2896.
Huh?
2896, page number 35. 20896. Now coming back to this paragraph number 15, lordship. It has been mentioned that in the conspectus of the above facts, the question that would arise for consideration of this court in this case is as to which are the rights and interests of the petitioner as a government servant that would remain protected under the Act of 1985 pursuant to his substantive absorption in the service of the board. The answer to the said question, this is important, lordship, the answer to the said question in the opinion of this court would lie in the correct interpretation of section 22(2) of the Act of 1985, which is reproduced herein below for ready reference. Now the provision that he should be absorbed substantively in the service of the board, and the board will absorb him substantively in service, and thereupon the services rendered by him under the state government shall be.
Where?
Yes.
Those issues are not
Exactly,
genuine.
lordship. Now the basic point that was raised, lordship, and that has been properly dealt with by the learned single judge, lordship. Here it is at page number 81, paragraph number 21. That hurdle was never been crossed by the petitioner by filing any affidavit in reply with regard to that. Paragraph number 21, it has been mentioned that the right of a government servant serving under the state government of Assam to receive pension is governed by the provision of Assam Service Pension Rules for short rules 1969, framed under the proviso to Article 309 of Constitution of India. Rule 31 of the rules of 1961 lays down the condition of qualifying service by receipt of pension. Rule 31 has been reproduced. Now the next paragraph, paragraph number 22. Rule 36 of the rules of 1969 further provides that service does not qualify the pension unless the officer holds a substantive post on a permanent establishment. Rule 36 is reproduced herein below for ready reference. Service does not qualify unless the officer holds a substantive office on a permanent establishment, provided that continuous temporary or officiating service under the government of Assam followed without interruption by confirmation in the same or any other post shall count in full as qualifying service, except in respect of periods of temporary or officiating service in non-pensionable establishment and period of service paid from contingencies. Now the next paragraph, Lordship. Since the employment of the petitioner, this is important, Lordship. Since the employment of the petitioner under state government was not made permanent prior to his absorption in the service of the board, hence he was not qualified under Rule 31 to receive pension. Since the board is a non-pensionable establishment, hence in view of the first proviso to Rule 36, permanent absorption of the petitioner in the service under the board will also not count so as to bring his case within the ambit of the pension rules. So he had not paid for his post that he was holding in the parent department for permanent. Since it was not done, subsequent to that, he was deputed to this particular department, Lordship, the respond number 2 and 3. At that point of time, this particular provision of the Rule 22 would come into play, and he is entitled to CPF only, and that is the reason why, Lordship, that was given to the petitioner. So the basic aspect of the matter has never been countered in by filing any affidavit in reply with regard to that, because this aspect of the matter has been dealt with in a proper way by the learned single judge, Lordship. When entire explanation is there, I'm just not reading to those explanation, Lordship. Entire aspect of the matter has been given in paragraph 24, 25, 26, and 27. Clarified the entire aspect of the matter that has been taken up by the petitioner in the writ petition. Because his service, the initial entry that was there, that was absolutely temporary. During that period of time, he was deputed to the subsequent department, the respond number 2 and 3. And that aspect of the matter has been taken into account. And because of that, his post was never been made permanent. He was not eligible, because whatever he is eligible in the subsequent department, he is entitled for that, and he was getting that aspect of the matter. So there is nothing irregularity and illegality in the order of the learned single judge, Lordship, and there is no scope for interference in this case.
May, please. My lord, Lordship may kindly peruse paragraph 12 at page 78 of the judgment. Paragraph 12. Opposing the submission made by the petitioner's counsel, Mr. Srenshaw, Learned Standing Council, Urban Water Supply and Sewage Board, has argued that the services of the petitioner under the government of Assam was never regularized, and therefore, being the temporary employee, the petitioner did not have any right to receive pension under the Assam Service Pension Rules 1960. According to Mr. Srenshaw, having failed to exercise his option for repatriation during the period of his deputation transfer to the board within the prescribed period of time, the petitioner had accepted that his service condition would be governed by the section 22(3) of the Act of 1985. If that be so, submitted by Mr. Srenshaw, the petitioner cannot now maintain his claim for the sanction of the regular pension. Even if it is assumed, my lord, his services were, my lord, confirmed and permanent, then also, my lord, the petitioner, after receiving the CPF, he cannot turn around. My lord, Lordship may kindly see his representation, my lord, page petition.
No, why not?
After retirement of service, my lord.
So what? If he has been wrongly given, why not?
No, my lord, it is not wrongly given. Page 57, your lordship may kindly see. He accepted. Page 57. The representation was, my lord, after his retirement, my lord.
Anyway,
He retired from service on 31/1, my lord, he retired from service on 31/1/2023. He filed his representation on 27/6/2023.
So your case basically is that because he has accepted the CPF,
My lord.
he cannot now say that CPF was not applicable to him.
My lord. Lordship may kindly see,
So even though he might be eligible for pension.
because my lord, his service is governed by the board's regulation, not by the pension rules 1960. My lord, lordship may kindly see one paragraph of the representation that was filed after his long after 5 months of his retirement. It is worth mentioning that page 58, my lord. The board has contributed 50% share in CPF account and page 58, bottom paragraph, last paragraph. It is worth mentioning that since the board has contributed 50% share of my CPF account and as I claim my monthly pension under the rules 1960, I am ready to return the share of the board contributed to my account to be resize 50% of the total amount accumulated in my CPF account or the same may be recovered from my monthly pension.
So what is wrong?
My lord,
What is wrong?
wrong means, my lord, he has accepted the, my lord, the conditions of the board's regulations, my lord, as per that he withdraw the CPF account. And then, my lord, after few months of his retirement, he turned around and said that, my lord, please.
No, but supposing he's entitled to it, then why can't he turn around? If he's entitled to it as per law, and supposing he was not entitled to CPF, then
My lord, as per my humble submission, my lord, he is not entitled as per the, my lord, page 34 order, which I would like to, my lord,
Page
if
34.
you travel to read again, my
no
lord.
problem. No.
Page 34.
Yes.
The government order.
Yes.
With reference to your letter on the quoted subject, I am directed to say that Siri Azizur Rahman, Assistant Engineer, should be absorbed substantively in the service of the board, and then board will appoint him as substantively in the board under section so and so of the Assam Urban Water Supply and Sewerage Board Act 1985. The services, this range, my lord, these services rendered by him in the state government shall have to be treated as service under the board. Under the board, and have enjoyed all the rights and privileges that it leave, pension, etc. in the same situation as he was enjoyed
Sorry, state government.
in the state government.
As you answered. That's it.
But under the board, my lord.
The last thing.
Last line, my lord, this is continuation, my lord. If I, my lord, this, my lord, condition is, my lord, he will permanently observe in the board.
Okay, we'll put it CAV and we'll.
I'll just point out two things, Milord. My lord, as far as my learned friend, Mr. Chaudhary, who appears for the board, I'm dealing with his case, Milord. Please come to page 78.
Yes.
Now, I'm reading from the fifth line, Milord. According to Mr. S.P. Chaudhary, having failed to exercise his option for
No,
repatriation.
no, which paragraph?
Paragraph 12, Milord.
12, yes.
Para 12, page 78 towards the bottom. Fifth line. According to Mr. S.P. Chaudhary, having failed to exercise his option for repatriation during the period of his deputation transferred to the board within this prescribed period of time, the petitioner had accepted his service condition would be governed by 22(3) of the Act. If that be so, submits Mr. So-and-so, petitioner cannot now maintain his claim for sanction of regular pension. That means, my lord, his specific contention was, my case would be covered by 22(3). Am I clear, my lord? Now, please come to, my lord. Just I'll refer to 2 pages, my lord. 3 I have already read. Now, my lord will kindly come to page number 35. The absorption order which was passed by the board after seeking clarification from the government. In pursuance to the government letter dated 25/7/96 and under section 22(2) of the so and so act, services of Sri Azizur Rahman is hereby absorbed with effect from the date of joining in the government service, that is 5/7/88. So, my lord, my absorption in the board with effect from 5/7/88 was under 22(2)(2). Now 22(2) says that I will get everything which I was getting under the government. Now here, my lord, they cannot bring in temporary, permanent and all these things. Now I don't think he can disown this letter. This is the corporation's letter, board's letter. Board says I am absorbed under 22(2). Now what 22(2) says, my lord? That I will get pension as if I was an employee of the state government. That means my condition of service will be not less favorable. I do not know on what basis they are opposing their case. It is his submission, my lord, which is recorded by the learned single judge at page 78, para 12. And as far as my learned friend's contention, my lord, I think he has misconstrued 22(2), my lord. It says that my service condition will not be less favorable. Therefore, my lord, it's a clear-cut case. It is this question of whether I am a temporary employee. That means, my lord, if I am a temporary employee, I will get CPF. I can become chief engineer. Does this argument lie at this 11th hour, my lord? If I am a temporary employee, my lord, where is the scope of, my lord, I understand if my appointment is under 3F, then there is a scope of regularization. When I am selected by the Public Service Commission, where is the further scope of regularization? Well, there cannot be opposition for the sake of opposing it. End of the day, we must deal with the issues. Therefore, my lord, I think the learned single judge has misconstrued, misdirected itself. And my lord, therefore, it's a fit case where lordships will interfere with the order of the learned
Support of
single.
my argument, my lord, I would like to read paragraph 27 of the judgment also, my lord.
I think we have heard everyone.
Yes. Well, only one judgment, my lord. 2022 15 2022 15 SCC 325. Regarding, my lord, switch over from that CPF from GPF is also permissible.
I would like to
What? 15 SCC. And my lord also will consider that case, mill. I'm very sorry, I forgot to, my note is somehow misplaced. I can find out, my lord, for your lordships. My lord, it's an authority for the proposition that it is permissible for shifting from CPF to GPF. In fact, my lord, lordship would recollect in 1986, Government of India came up with an OM that whosoever is on CPF, they will be deemed to have come to GPF unless they have exercised the option otherwise. It was in that context.
And Mr. Kane.
my lord, may I please, my lord?
Oh,
I want to rely one argument. That is, my lord, 2024 9 SCC.
yeah, I'm going to take it. You have been take that.
Paragraph 46.
Vinod Kumar, others.
No, my lord,
The other one.
Citation.
petition,
This, Nityanand.
I have not written.
You have not read it.
I have not, my lord, but the name I have forgotten. My lord. 2024 9 SCC,
Page
page 331, para 46.
331 then.
The name of the parties I forgot. Paragraph 46.
Uttar Pradesh Roadways.
Yes, my lord.
Pension is not a right and not, is a right and not a fault. That's that part.
Yes, that part.
That helps me. Not about.
To help my learned friend, my lord.
No, if the
Since I fail to understand everything.
No, no, my lord, my learned friends, when he says it's not a right, it's not a
But it was
boundary,
my
but it's a right, then he definitely supports me.
Only one line is not sufficient and of a paragraph
Anyway,
for my learned friends information.
Okay, right, heard Mr. K. Chaudhary, learned senior counsel for the petition, for the appellant, assisted by Ms. R. Chaudhary. Also heard Mr. S. P. Gupta. Chaudhary for
respond number 2 and 3.
response number 2 and 3. Mr.
Sharma, DK Sharma.
For
This one number 1.
and Mr.
C. Sharma for response number 4.
C. Sharma for
B. Sharma for.
C.
Response
Sharma
number
for
4.
AG.
Oh, response number 4.
response number 4. Hearing concluded, judgment reserved.
deep love.
Obliged.
Give this back. Yes. Yes, Mr. Gupta.
My lord. My lord, here, there was an order of recovery, my lord, from the employees, my lord. They were granted the third MACP benefits wrongly.
Wrongly meaning they were not supposed to get it,
They
or they got a higher amount.
They were not entitled to. The point of time which
You
they
were not
ought to-
entitled to, it, so.
they have got earlier. Normally, my lord, the third MACP benefit is on the completion of 30 years of service. So they got the benefits earlier. Later on, it was, my lord,
So you have asked for recovery of that amount.
yes.
Then they put that to challenge.
They put that to challenge before the tribunal, my lord, and the
What did the
applying
tribunal say?
applying the principles of, my lord, in Rafiq Mashik
Traffic Mashik.
case, my lord,
What are they? Grade 3.
grade 3. They are grade 3.
Group C.
Group C. Group C, my lord. So that principle was applied, my lord. So in my humble submission was that principle is not applicable. In case of excess pay, my lord, recovery can be made, and also, my lord, in the circumstances where, my lord, these employees have given an undertaking.
Oh, they've given an undertaking.
They have undertaken, my lord, because every time when the pay is revised, my lord, if I may place, my lord, the order of
What did the tribunal say regarding that undertaking?
no, regarding the undertaking, my lord, since these undertaking are inbuilt, my lord, when
What did the tribunal
My lord.
hold with regards to this? Despite the undertaking, did it allow the case of the respondent?
my lord, paragraph 10, if I may take, my lord, page 66.
Yes.
It is an admitted fact that the applicants were granted benefits of third MACP on from 2012 to 2014 on different dates with regard to different applicants. However, while orders dated 6/8/18, 23/28/8/17/7/9/18, respondents have withdrawn the benefits granted to the applicants in a different dates from 2012 to 14 and has refixed the pay from a subsequent date, revised date of eligibility which
Where is the mention with regard to the undertaking?
no, that's what I was submitting, my lord. These undertaking are
Did you bring to the notice of the tribunal the opponents had made an undertaking that they would repay any excess payment made?
yes, my lord. I am just my lord, I will point, my lord, to my written statement which was filed.
You see, we are only looking at whether there was any infirmity with the decision taken
My lord,
based on the materials that were placed before the tribunal.
my lord,
Now,
my lord,
if you have not taken that point
my lord.
regarding the undertaking having been executed by the respondent,
Yes, my lord,
that they would repay
my lord,
any excess payment or any wrong payment made to them,
my lord.
then you should file a review before the tribunal.
No, my lord, that,
Because can we now decide
my lord,
that issue
my lord.
in an appeal which was never brought to the
That
notice?
was, that was taken, my lord. If my lord, I may take my lord to page 48, paragraph 3.
Page 48.
48, paragraph 3.
Page 48, paragraph.
Paragraph 3, this is, my lord, our written statement filed before the tribunal.
Yes.
That with regard to the statements made in paragraph 4.3 of the original application, the respondent begs to state that the third MECP financial benefits were granted erroneously to the applicants during the year 2012 to 14 had to be withdrawn during the year 2012 18. The applicants who are working in this administration for more than 3 decades are fully aware, and it was well within their knowledge that the MECP was given wrongly to them and could be recovered at any time. It is the duty and responsibility of the competent authority to correct the mistake, and accordingly, the MECP, which was
Sir Counsel,
no, it is
you are
there.
only saying that they were in the
No, it
knowledge.
is there.
Where is your averment
It is
that
there.
undertaking had been executed
It
by
is there,
them?
my lord. The subsequent lines I am reading, my lord. The applicants have not objected to the revised order of third MECP and also the subsequent pay fixation order. My lord, the pay fixation order.
Mr. Counsel, where are the documents that you submitted before the tribunal?
My lord,
See, it's one thing to say
my lord.
that they were aware of all this. But it's another thing to say that they had given an undertaking.
No, that is what I am trying to submit, my lord.
You see, if you say that they had given an undertaking and they had signed it, then it binds them.
My lord.
But if you say that it is in their knowledge, that knowledge can be in the mind only. How do you go and try out that knowledge? I
That
don't.
what I would like to respectfully submit, my lord. This is not an undertaking which have to be given separately. My lord, whenever a pay is revised under the rules, my lord, under the Central Civil Services ROP rules, which I have given, my lord, the copy. Yes, yes. My lord,
So
the last page, it is inbuilt, my lord.
Okay, last page.
My lord will take rule 6. My lord, I am reading.
So this undertaking is inbuilt.
Yes, my lord. No, the last page, if my lord will take of.
Since they did not give an undertaking, the undertaking was in the rules.
Yes, yes.
Did not give it separately.
Yes, my lord. Yes, my lord. Yes, my lord. That separately it is not required, my lord.
And
Because
that is what you had said.
Yes.
In the beginning, you said that they had given an undertaking. So they had not given an undertaking. The undertaking, according to you, is not
It is
executed by
inbuilt.
them. It is in the rules.
It is in the rules, my lord. It is in the rules.
And I doubt whether that word undertaking would be used in the rule.
Yes, it is there, my lord.
Let us see.
My lord, if my lord will take the last page, second last page.
Yes.
My lord, rule 6.2 is the form of option. The next page is the undertaking.
Correct.
I hereby undertake.
This that is what we are asking you. Where is this?
Given.
This is what I'm saying. This is the form.
I have given the copies, my lord, the undertaking which they have given.
No, Mr. Counsel.
My lord.
Again, not answered the
My
question.
lord.
Was this undertaking, this form in which they have to sign,
Yes.
whether this was brought to the notice of the tribunal?
That perhaps will have to check from the.
No, that is the issue. There is nothing here
No.
which shows that this undertaking that had been signed by them had been brought to the notice of the tribunal. In that case,
No.
go to the tribunal, you file a review saying that in view of this undertaking and in view of the judgments passed by the Supreme Court, the undertaking has to be complied. That's all. Now, otherwise, what you're asking us to do is to decide the decision of the tribunal
No.
sans this document. Naturally, we'll say that the decision of the tribunal was not complete, was not correct. But because we did not consider this aspect. You would have. You would have. It's simple. There's nothing to be decided here.
No.
I understand your case. Your basic case is that since the undertaking is there and there are some decisions of the Supreme Court,
Yes.
they are bound by that undertaking.
My lord.
But you have not given this, you have not brought this undertaking to the notice of the tribunal. That's all.
No, under the ROP rules, my lord, when the pay is fixed, my
Mr.
lord,
Counsel,
it is,
look, it is, you said it is inbuilt under the rules.
my lord.
The inbuilt under the rules requires that it has to be signed by that person.
My lord.
Then you give it to them, show it to the thing.
No, in that case, my lord, I will, my lord, seek instructions, my lord, whether it was submitted before the tribunal or not, my lord, because
There is that.
courts must have been called from, my lord, we have this.
Mr. Counsel, you have, either you are, you see, this is the document that you have submitted before the tribunal.
My lord.
It is before this court. Now, if you are saying that you have not submitted the entire list of documents
No,
for us, then you are hiding facts from us,
no,
playing around.
no, my lord,
We'll issue contempt notices.
my lord will take page 84, my lord, if I may point out, my lord. Page 84. This is the pay fixation order. My lord will see the last paragraph. The above
Mr.
fixation
That is
is
another,
subject to, my lord.
that is something to agreed. That-
Yes.
But where is the undertaking signed by them that if there is any excess or wrongful
my lord.
treatment, we will repay the amount.
My lord, if I may submit a short reply, my lord, here, my lord. My lord, in this case, question is, my lord, about recovery.
Correct.
Not about refixation and revised order, my lord, nothing is there, my lord. What has happened, these applicants are the employees of All India Radio, my lord.
Correct.
They were given erroneously, that has been admitted. And the law is very much settled, my lord, in this regard, that if you have given erroneously, there are Supreme Court judgments that Group C employees, and after their retirement, it cannot be recovered, my lord. They have accepted. I just want to point
It can be recovered provided there's undertaking law. There are some other judgments of the Supreme Court.
My lord, I
So you see, we are not on that issue. We are not on that issue right now.
yes,
The issue of, you see, he has said that an undertaking was signed by you. And because of that, the decision, just a minute,
my lord.
and because of that, the tribunal has passed the wrong order. So we have taken a view that unless that issue was brought to the notice of the tribunal,
Exactly.
we are not going into the merits of this case. So if he wants, he can go back to the tribunal. So that's the long and short of it. There's no point.
That's correct.
That's all.
I was just submitting that there is no issue other than recovery, my lord.
Well, anyway, we understand your point of view. You're referring to Rafiq Masi and all the others.
Yes, my lord, law is well settled.
Anyway, right. Right, Mr. A.T. Gupta. Learned counsel for the writ petitioner who submits that the impugned, what is that? The impugned what is that? Impugned order dated 28/3/24 passed by the Central Administrative Tribunal among Guwahati bench in original application number 040/001/22/2022. By which recovery of the excess payment no, excess / erroneous payment made by the appellants to the respondent in respect of the third MACP scheme, is it?
Third MSCP benefit.
Third MSCP benefit was set aside. No, was set aside. Has been put to challenge. Next one. The learned counsel for the writ petitioner submit that the respondents who are employees of the All India Radio / Doordarshan Kendra, Guwahati were granted the third MACP benefits on a date prior to their entitlement.
Yes.
On coming to learn that the respondents had been granted the third MACP benefits erroneously, the respondents took a decision to recover the erroneous payments made to the respondents. The respondents, the respondents thereafter approached the CAP Guwahati bench while OA number 122/0/2022 for setting aside the decision taken by the appellant for recovery of the erroneous payments made to the respondent by taking support of the decision of the Supreme Court in the case of Trafficking versus State of Punjab. What is that?
The state of, no, it is state of Punjab and others versus Rafiq.
Punjab and others versus Rafiq Masi.
See,
What is that? Rafiq Masi, something was the
in
bracket.
bracket, my lord, whitewasher and others.
Whitewasher,
Washer and others, my lord.
whitewasher, bracket close and others. Reported in
2015, my lord, 4 SCC 334.
2015 4 SCC 334. Pustam. The learned, the learned tribunal thereafter, by the impugned order, disposed of OA number 040/00122/2022 by setting aside the decision of the appellants to recover the erroneous payments made in relation to the third MACP scheme on the ground that the respondents belong to class 3 service and a recovery from class 3 and 4 employees was impermissible in law. Pustam. Next paragraph. Just read from the beginning. I've forgotten the plot. No, before that. Records. Okay, next, you're right. The learned counsel for the petitioner's counsel submit that the respondents had executed undertakings at the time of taking the third MACP, at the time of taking the benefits of the third MACP, that in the event of the pay having been fixed in a manner contrary to the provisions of the, what rule? Provisions of the the CCS bracket revised pay bracket close rules, comma 2016, comma as detected subsequently, comma any excess payment made would be refunded to the government. What have I said? Just read. Good stuff. He submits that when the respondents have had made undertakings that they would return the erroneous payments made to them, comma, the learned tribunal could not have issued the impugned order, setting aside the decision of the respondents to recover the erroneous payments made to the respondent. Next.
It is at the time of revised pay scale, not at the time of third MSCP when the.
At the time of revised pay scale.
Yes.
And where the.
This is, if I may,
Anyway.
if I may give.
Anyway, the thing is this, have you taken this issue up with the tribunal?
No, statement was there in the
The statement,
WS, my lord.
the undertaking, that word undertaking should be there.
No,
If it page 51 is there.
page 48, my lord, pay fixation order. When the pay fixation order is made, my lord,
Mr. Counsel,
my lord.
I do not know whether, why you trying to, you see, this, you have shown me this.
Yeah,
This, what is
Yes.
this called? This is not called a promise, this is not called a sale deed, this is not called a lease deed.
my lord.
This is called undertaking.
Yes.
Then, that is why I want you
I'd
to
like
find that word
if I
under.
may give that, my lord.
No, no, please give me this.
My lord, will just come to the.
No, okay, no, you're not listening, forget
No, no.
it. What have I said? Had made undertakings to the effect that they would, the erroneous payment at the time of, no, in terms of censor, whatever, don't say. We have considered the submissions made by the council for the party. There is nothing in the averment made in the pleadings of the writ petitioners before the learned tribunal that the respondents had made undertakings, had executed undertakings which bound them or which required that they would have to repay the erroneous payments made by the government. With regard to the third MACP scheme. As such, we do not find any infirmity with the decision of the learned, with the decision of the learned tribunal in deciding the matter on the basis of the decision of the Supreme Court in Trafficking Massive Super. However, in the event the petitioners are able to trace out the undertakings which had been allegedly executed by the respondent, which bound the respondents to return any erroneous payments made to them under the third MACP scheme. Under the benefits under the third MACP, the petitioners are given the liberty, the petitioner is given the liberty to approach the learned tribunal afresh by way of a review petition or otherwise as they said, issue regarding submission, regarding execution of an undertaking by the respondents, and the undertakings itself had not been brought to the notice of the learned tribunal. The writ petitions according, heard, Miss U data appears for
Respondents.
respondent,
There are 4 respondents.
appears for all the respondents.
Yes.
The writ petitions accordingly dismissed.
Disposed, my lord.
Huh?
Disposed.
Why disposed?
There is a direction to go for a review, my lord. We'll
Liberty is
Given that's
granted by
fine.
your lordship. Liberty is granted there.
Granted,
be disposed, my lord. It should be
There is nothing.
disposed of, my lord.
Huh?
It will be disposed. Because we'll approach by filing a review, my lord, because there are documents
Oh, the-
to be disposed of.
My lord,
Click close.
yes,
For what? Close then.
my lord,
Dispose of
just,
what?
it is over, my lord. Just 2024 judgment, Jagdish Prasad Singh versus State of Bihar. It said that even the excess amount should be refunded if recovery has been made, my lord.
No.
There is judgment.
No, the Jagdev Singh judgment I
So-
have, my lord, which I have not placed because my lord is saying we have not annexed the document itself. Otherwise, I would have relied, my lord. Jagdev Singh, my lord, in case
It's not Jagdev Singh.
yes,
Jagdish Prasad.
that is that judgment, my lord, where recovery is permissible in case of an undertaking.
Hmm.
2016-14 SCC 26.
Okay, is accordingly disposed of.
My lord.
Much.
Right.
Yes,
The IA is for, my lord,
WO filed,
yes, IA is for,
then any eyewitness?
no, my lord, there is no eyewitness. Only, my lord, conviction is only on the basis of, my lord, the last seen together. Only on the basis of last seen together. That is also by a police officer saying that on the last.
Note
One,
yes.
lordship, the police officer means there was a case, lordship, before 24 hours of her death. That she was with the accused and police have caught them. They were in the
They were allowed.
Some other day.
lordship.
It was,
Yes.
we were slightly pressed for time.
Lordship.
Right, in
The
the,
Indian paper.
appeal, you're right?
Prepared.
the
This year.
registry to prepare the paper book. List the matter after 2 weeks.
After vacation. There's a tutor next
2
week.
years, only to 2 years passed.
Yeah, it's okay. List the matter after vacation. No hurry. That's. This is. We try. No. Yes, madam.
May I plead your lordships? Lordships, in this matter, Mr. R. Borpujari is conducting
Yeah.
this matter. He's on legs at foot number 15.
Okay, right.
Lordship.
Adjourn,
Any other day, your lordship.
adjournment prayer has been made as Mr. R. Borpujari is on legs in another court. List the matter after a week.
After, next week, your lordship.
List the matter the next.
Deeply obliged, your lordship.
Right, as, no, who's for the, yes, for.
Lordship, I have received the information, lordship. Notice served, but the IO have sent through WhatsApp, lordship, so it was not very reliable to give lordship. Otherwise, it is served. What is this, sir?
Right, Miss A.
I have asked them to give a hard copy.
Begum, additional CP, submits that notice has been served upon the respondent number 2.
Lordship.
And she will be submitting a
Hard copy in the next.
hard copy on the next date.
next week.
Gustav. Registry to prepare the paper book. List the matter after the vacation. Then in the IA, you've got to file written objection. Not yet filed.
Lordship, I'll
State
file.
Begum is granted 4 weeks time to file written objection in the IA.
Motion fix a date after.
Section 430 BNSS.
4:30 p.m. After vacation.
This is the matter after vacation. Letter 14.
Lordship, this letting will be taken up after some time, Lordship.
Paper book is made 21C.
Yes, Lordship.
Lordship, Lordship, the argument continues
21.
from another court. It may be taken up after some time, Lordship.
There's no time.
Lordship, he will come, Lordship.
He will come, but.
After the next matter,
Okay,
Lordship.
we'll wait for some time. They will be here.
Lordship.
See what. Give it.
May it please your lordship, as per the last office state order dated, my lord, the steps have not been completed, my lord. So I may be allowed to take steps to the department, my lord. Because in the writ petitions, they were already, the copies had been served and they had participated, my lord.
Yeah, so you are supposed to take steps
Yes, my lord.
and you have not taken steps.
I had taken steps, however, the AD card has not yet returned, my lord.
So then what do we do?
My lord, either we take it through the office or my lord,
Appearing for whom?
Respondent numbers 2 to 8.
2 to 8
2 to 8. And you are appearing for?
He's with me.
to the office.
How many respondents are there?
My lord,
24.
24, 9 to 24, my lord.
Okay, Mr.
Zorawar Singh.
Zorawar Singh appears for the respondents number 2 to 8.
Please, Manoj.
So what do we do with the other respondent?
My lord, we may be allowed to take through them because they are the employees of their company, my lord, insurance companies. And they're posted at different circles.
Well, these are private respondents. This is a matter with regards to promotion. He's challenging that he should have been promoted because he's meritorious. And 9 to 24 are private
You have
respondents.
not taken steps.
My lord, I have, my lord. There is a note, my lord, last order.
Wakalatnama file number 2 to 8. And then by the pen, I return answer whether they card or something. Notice is issued when? 6. 4 8. 6 8. No. Has been issued
4 in, my lord.
so notice 4 8. Today is what?
Today
10th
is
of September.
10th of September.
We'll wait for someone.
My lord, the person will go into retirement next year, my lord. Either my lord may also allow me to
Fresh steps.
paper publication also will do, my lord. I'm ready for that also.
Where are they?
My lord, they are in different parts of the country, my lord, in Chennai, Bombay. That's why I was requesting my lord that if my lord may allow me to take to the office because if they say the companies which they work, they are under him, my lord.
Why don't you inform them?
By a circular,
You can inform.
Unless the petitioner is still in service. There is an net which is available to him. There's a proper portfolio, online presence which has details of all employees.
Yeah.
All of their official email addresses are there. All of their other details like mobile numbers, everything is present on that platform.
we have mentioned.
All he needs to do is open it up and send them by email. Then that service should also be enough.
By email.
My lord, yes, my lord, I have.
I should not be burdened with serving his respondents.
My lord, in fact, in my appeal, I have categorically mentioned about the email IDs of all the persons and their phone.
Send them.
Yes, my lord. My lord may allow me through email service, my lord.
Okay, right. There is no return of AD card or unserved notice with respect to the other response. As it has been submitted that the appellant has the email address of all the other respondents.
My lord.
He is also allowed to serve notice upon the respondent. The other respondents through email and WhatsApp.
My lord. Much obliged, my lord.
Meanwhile, I have filed a response, an affidavit in opposition to their additional affidavit. That may please be brought on record minutes.
It's not on record.
It's not on record minutes. I had filed
When did you file?
yesterday.
Wait, it's
That's
now
it's-
automatically.
That's it.
My lord may.
And
You have to see whether it's under objection or.
I will also file a affidavit in opposition to the rate of agents.
My lord, I may be allowed to file an affidavit after taking steps to email.
The appellant shall file an affidavit of service thereof.
Much
Can I
obliged.
request for a particular date, Manoj?
When? Give a date.
Anytime post
30th October.
30th October is convenient.
Unless the matter on 30th October.
Highly.
Much obliged.
Yes.
Yes.
21C,
Yes, sir.
heroin.
Yeah.
Then what is the ground? You
Yeah.
want your IA to be disposed of or what? So 21C, then
Yes.
what is the ground?
Lordship, the first thing is that the independent witnesses that were being called in were called by the police themselves.
How
And
does that matter?
They are certain.
Witnesses have to be called by someone.
So there were more than 20 to 25 people present out there, according to the evidence of the independent witness themselves. And there are case law.
No one's going to just come and be a witness. You've got to call them. Someone has to call them.
Now, Lordship, there were people more than 20 to 25.
What does it matter? Okay, that is one ground. Then number 2 ground.
Now, there is a case in respect to this, Your Lordship. I would like to cite where it said this is the case passing by the this court, Honorable Body High Court, where another important aspect as submitted by the learned counsel for the appellant was that there was no independent witness to the search and seizure in the instant case. Section 100 subsection 4 of the CRPC provides that before making a search, the officer conducting the search has to call upon 2 or more independent witnesses responsible inhabitant of the locality in which the place to search is situated or
Fast rule. Supposing they make a seizure in the forest, then what happened?
now.
There is no locality in the forest.
Now,
What happened?
that is a different circumstance, Worship. But here the people were present out there. According to the witness, there were more than 20, 25.
You see, you can't, you see, in these you cannot go around asking, are you from this locality? Are you from where? Then, okay, that is one. Then number 2.
He have also witnessed.
Number 2 point.
Now, Lordship, the body that was not being searched, that I submitted on the last occasion.
Body.
Yeah, body of the the
Was the
person who
recovery
entered
made from the body?
the mechanic who entered into the vehicle was not being searched by the investigation authority there, and also the IO and the other police personnel who entered to the vehicle at that particular point of time. According to the
So according to you,
Yeah.
the heroin was brought into the vehicle by those persons who went inside.
No, for the Lordship, the Supreme Court also has said that these are like fairness of the trial, and the fairness, this must be done, Your Lordship. If not mandatory, this should be done, Your Lordship. This has been given in various judgments also. And moreover, Your Lordship, the kits that were used was not, the IO could not exactly say what kits they have used, how many numbers of kits they have used for the same. Moreover, the signature of the accused has not been taken in each and every seized package, Your Lordship. And the standing orders that was passed in 1988 also not being mandatorily followed in this NDPS matter, Your Lordship. These are the various circumstances.
Those are neither here nor there. I mean, those issues meticulously we'll see at the time of hearing.
Now, Lordship, he belongs to Manipur, Your Lordship. He is a citizen of India. He may be given an opportunity to go on bail, Your Lordship, because he is
Whether he's a citizen, whether he belongs
he will not
to Manipur or
abscond.
Mizoram or Nagaland or Arunachal doesn't make a difference.
He has been behind the bars since 2 years, 5 months, Your Lordship.
Only you see, this is not a question of a UTP being behind bars. This is a question of a convicted person.
Yes.
There's a difference. You're talking of UTPs. That those decisions with regard to bail are with regard to UTPs. This is a convicted person
Yes, sir.
where he has been found guilty by the trial court.
Found guilty by trial court.
And is a commercial quantity.
Yes, sir. But he is just a driver in that vehicle. It has been said in the judgment that he's just a driver to keep the passenger from one place.
No one is going to transport drugs by foot. I'll tell you that much. They have to, if you're going to go from Manipur to Bombay, you're going to go by some vehicle or the other, or train or plane. No one is going to go by foot. So just because he's a driver doesn't mean that.
But nothing has been seized from his conscious position.
But from his vehicle.
But his vehicle, it may be in the vehicle, it may not be in his sense, Your Lordship, because the vehicle doesn't belong to him. The
Maybe.
owner of the vehicle is somebody else.
So who was there in the vehicle when it was when
He was alone. Your Lordship.
he was alone?
He was going to Guwahati to pick up a person.
It usually happens Drivers are usually caught.
But nothing has been got from his pocket or something.
Oh, how much was seized? Half kg?
Yeah, 5 point something.
Half kg. No one is going to put half kg of heroin in his pocket. Have you ever carried half kg of dal in your pocket? Okay. Right. Huh? Oh. Heard Mr. S. Ahmed Leonard for the applicant defendant. Also heard Miss
S.H. Bora.
S.H. Bora, additional people. This application under section 430 BNS is for suspension of the sentence passed upon the applicant pursuant to the judgment dated 25/25 and sentence order dated 29/3/2024, by which the appellant was convicted under section 21C NDPS Act 1985 and sentenced to undergo a rigorous imprisonment for 12 years with a fine of rupees 1 lakh, in default of fine SI for 6 months. The prosecution case is that heroin weighing approximately how much?
565.28 grams.
565.28 grams had been recovered from the vehicle driven by the applicant. No one else was an occupant of the vehicle except the applicant. The counsel for the applicant submits that the persons who did a search of the vehicle were not searched by the police to ascertain that they did not carry any so they did not carry the seized contraband into the vehicle. But he also submits that even though there were more than 20 people near the place of seizure, the independent witnesses were not called by the police. He further submits that the witnesses were not from the locality in which the seizures were made. What else? What else did you take?
The VB secretary was also being present in that particular.
Who?
The VB secretary.
BB secretary?
VB.
Today's defense party.
The VDP.
He was also present in that particular.
So?
He also made not a independent.
He also submits that the village defense party secretary,
Yes.
who was also present at the place of seizure, should have been made a seizure witness. But the said person was not made a seizure witness.
But Lordship of the cross, that is deposition of PW1 Lordship. That is, it has been stated at the time of checking on the vehicle, there were 20 to 25 people present except VDP members. So that means VDP members.
How does it matter whether
Yes,
VDP
documents.
member is made a witness or not? In fact, VDP members, you'll have to eye them with a little suspicion because they want to make sure that you are behind bars.
The independent
Whereas
witness
they might
himself,
not be as independent as you think they are.
he himself has stated that he has been called by police on various occasions to be a witness in this kind of cases.
So VDP member.
No, the independent witnesses has submitted India 164 statement.
Sometimes there are professional witnesses, could be. Maybe. But we'll see that. He accordingly submit that she submits that as the applicant has been behind bars for 2 years.
2 years, 5 months.
2 years, 5 months. The granted pay by suspending the sentence. Last one. The learned additional PP on the other hand submit.
Lordship, I'm relying on the PW1, 2, and 3, who happens to be the independent witnesses, and from their evidences, it reveals that the contraband is recovered from the conscious possession of the petitioner, and he has got deliberate intention to conceal the contrabands inside the vehicle.
Submits that the evidence of PW 123 goes to show that the seized contraband had been recovered from a secret cavity in the vehicle driven by the applicant who was the lone occupant of the said vehicle. During the time of seizure, a number of people were present, and there is nothing to show that there was any wrongdoing at the time of seizure and arrest of the applicant. On considering the evidence of PW 1, 2, and 3 and the
Investigating officer, PW 6.
and the fact that the applicant was the lone occupant of the vehicle wherein the seized contraband had been recovered. We are not inclined to allow the present application at this stage. The application is accordingly rejected. In the main case, right, as the paper book has been furnished to the parties.
No, I have not received.
Not received.
I have received.
You have received.
Yes, sir.
Is there extra copy? Give it to you. As the paper book has been furnished to Mr.
Yes, Ahmed.
S. Ahmed, Learned Counsel for the appellant in the court today. And as Ms. S. Bora, Learned Additional PP submits that she has already received a copy of the same. This is the matter for hearing when?
Yes, your lordship.
Application. Go ahead.
Thank you, please.
Obliged.
Sorry for interfering, but in regards to item 13, so your lordship was pleased to dispose it of a small observation may be given that the judgment and decree is set aside.
Consequently, the impugned judgment and decree dated so and so, passed by so and so, in so and so is set aside.
Obliged, lordship.
Please, your lordship.
So paper book has been, is to be made, correct? Is to be made.
Today, the opposite party, the informants notice is already taken step by.
I know, the steps have been taken, but stood only on 26/8. So we have got to await service report, okay?
I done it, friend.
Yes,
Oh, you are appearing?
yes.
Yes.
Then
Respondent number 2, my lord.
Okay,
Today I had 5 locals.
are you filing your written objection to the application
Lordship,
Yes.
there's an IA for suspension of sentence. Could the applicant will file objection?
within?
Post after vacation.
Okay, right. In the appeal, you write,
Yes, sir.
registry to prepare the paper book, this is the matter on your
What's the
date.
fixed date, please, coming from remote area here.
When do you want?
Just.
4th November.
Lordship.
Then in the IA, right, Miss
S6 for.
S.H. Bora, additional PP and
A
Mr.
Dutta, my lord.
Huh?
A Dutta, respondent number 2, my lord.
A data for the respondent number 2.
Yes.
Submit that they will file written objection to the application under 430 BNSS within 3 weeks. This is the
Yes,
matter.
lordship. Yes.
This is the matter.
Obliged.
The same day. This is the matter on same. Mr.
Jayadash,
J. Das, Learned Counsel for the
legal aid counsel.
legal aid will submit that there is a delay of 6 days in filing the appeal. Ms. S.H. Bora, PP submits that she has got no objection to the delay being condoned. Accordingly, the delay is condoned. Registry to release the appeal in a week's time. I is accordingly disposed of.
Obliged.
Or delay will
Any objection? Any objection to the delay being condoned?
No, I have not received the notice.
It is just 49 days. We'll allow the appeal, allow the condonation. Right. heard Mr. P.K. Roy, learned senior counsel for the applicant who submits, there's a delay of 49 days in preparing the writ appeal. Mr.
I have not received the notice.
I know, but 49 days, do you have any serious objection?
But the head office of Food Corporation of India, the offices, controlling offices here only. And it was, the order was passed in the month of December.
49 days, Mr. Counsel, anyway.
Yes, as you,
Okay, right, Mr. What is your name?
G.K. Gupta.
Mr. G.K. Gupta appearing for the petitioner objects to the delay being condoned. Full stop. You object to the delay being condoned and submit that he has not received a copy of the application for condonation. Full stop. Next paragraph. On considering the grounds for the delay as provided in paragraph 2 of the application, we have the view that sufficient cause for the delay of 49 days has been made out. Accordingly, the delay is condoned. Registry to list the appeal within a week. In the meantime, Mr. P.K. Roy shall furnish a copy of the writ appeal to Mr. G.K. Gupta within 2 days.
Item 20.
May I
Yes,
please-
madam, you're not taking step.
Yes, Lordship, as per order dated 19/8, we have implemented the auction purchaser as respondent number 6 and steps has been taken, Lordship.
But
It has been taken, Lordship,
as
yesterday only.
yes, 8/9/25, day
Yes.
before yesterday order, no steps have been received. When did you take step?
Yesterday, Lordship.
Yesterday.
Yes.
Miss
As Yasmin.
S. Yasmin appearing for the petitioner submits that steps for service of notice upon the respondents has been taken. For notice upon respondent number 6
Yes,
has been taken yesterday.
yes.
Accordingly, list this matter after the vacation.
Much obliged, Lordship.
Obliged, Your Lordship.
The interim order passed earlier.
But this is a review.
Oh, what is this? No, this is in the writ petition. In item 20.
No, I'm sorry, 20.
The interim order shall continue till the next day.
Much obliged, Lordship.
The matter has come for the first time.
Item
21. It's for review of the judgment passed by in the appellate court, my lord. The matter has come for the first time. Although my lord, the respondent has filed the my lord, affidavit in opposition. After that notice may be issued and the matter may be placed for my admission. In the meantime, I'll submit my reply against the affidavit in opposition. Formal notice has not been issued.
Well, it's last time, as a matter of fact, it was listed before another bench, one of Honorable the Chief Justice. It was said it will be heard on the next date and I will be given liberty to file my reply. If my learned friend has an objection to my reply and he wants to file a rejoinder, I will not take press upon my reply also. We can proceed with the matter today and finish it. As a matter of it's been hanging for some time, as a matter of fact. They filed the appeal, the review in April, they circulated it in June. Now the delay was condoned on the last date and it was supposed to be argued today. My client is facing dire hardship.
though they got some kind of a relief in the first portion of the order. The latter part of the order was helpful to you, I think.
My lord, that was
Because the interest portion is going to go sky high.
not only that, my lord, the second portion of the
Your appeal was a double-edged sword in a way.
appeal was allowed and then my lord,
But then the second
last part, my lord, that was my lord without any pleading, without any argument, no issue was framed either in the my lord before the single judge, not before the appellate court. My lord, question of my lord, the violation of principle of natural justice also comes in, my lord, because I am not heard. And this
But all the issues that you want to raise today, why don't you raise it there?
I cannot raise because this court has already, my lord, has said
Has given some findings.
that he is a supplier, I am a my lord, buyer, my lord.
So supposing we take
The
away
proper
those
law-
findings,
Law was the
that those issues can be decided by the certification council.
Yes, my lord, this, my lord, that, my lord, the council will decide whether he is a buyer or I am a supplier. But per se, my lord, it's a works contract. It's not within the purview of the MSME. That act, my lord. It is not, it does not, my lord, it does not. It is only, my lord, goods and services. And that is,
Basically, what you're saying is that, okay, let it go to the council, but let the issues remain open
whether he is a,
with regard to whether he can make a claim under that act.
under the act, and my lord, whether I am a supplier, the buyer.
Naturally, that's what. That is the case only. The long and
And
short.
the second issue, my lord, the works contract, my lord, it's a per se works contract, my lord. It is not within the.
Have agreed with the single judge's order.
My lord.
You should have agreed with the single judge's order.
My lord,
You were the one. The single judge's order was that the single bench had basically said that at the end of the day, you were the one who benefited from that order, from that work, and that the grievance you had against that principal contractor was with regard to some other portion of the work, not with regard to the work that he did.
Issue was that not the court, the
You operation successful, patient death type of thing.
My lord, dead means, my lord, remain in coma. My lord, it's
what you would have paid, though you would have paid 10 rupees. Now, if he goes to the council with all these observations, you will have to pay probably 100 rupees.
my lord, if the liberty is given, my lord, to decide, my lord, to the, my lord, council to decide whether he is a, my lord, supplier and I am a buyer for this particular, then, my lord, this will never succeed because this works contract is not.
Mr. Council.
Works contract is
My
within the
only
purview.
short submission is this. I am absolutely okay with the single judge's order even today, my lords. Because there are 4 other authorities, there are 4 other departments who had also conducted work. They paid the monies to them, even though they did not have any direct contract with them. They were also subcontracted, they were sub-agencies. I'm unable to take out the.
What we can do, you talk to your client. If you are agreeable to the single judge's order, then
Very simple nominal interest, Manoj, because I was out of pocket. I'm sorry, Manoj. Yes.
So if they are agreeable to pay the amount that is due to him, because this.
I'm out of pocket since 8 years.
This is not only, my lord, the order or the money part, my lord. This will have a, my lord, wrong precedent, my lord, for all the time, my lord. Whenever principal contractor fails.
This is going to be a one-off settlement between you two.
Yes.
It is not going to be based on any judgment.
Peculiar facts of this case, my lords. Peculiar facts.
You see, one thing is that at the end of the day, he has done his part of the job. Your grievance with the principal contractor was with regard to a different portion of the contract work, not with the portion that he did. Now, unfortunately, you're going to lose money, and he also, for no fault of his, he's going to lose money.
So only the lawyers are benefiting, actually.
But that's why you are smiling.
No, my lords, I don't. I am out of pocket. My client is out of pocket. He will like to see the color of money, my lords. He will like to see the color of money. He's being declared an infidel today.
Seeing your face on TV, he'll say, "Arey, my lawyer is smiling all the way to the bank."
No, I want my client to smile, my lords.
Totally on the question of law and the, my lord.
No, at the end of the day, you see, that's the only solution. Otherwise, of course, we have to have a hearing as to whether the finding or the observation made should stand.
Yes, my lord, that those would be,
That
with all respect, my lord, those were redundant. In fact, my lord, when the decision was taken that the judgment need to be set aside and the ground on which the.
So why don't you, the easy way out is if you pay him his dues, that's all. If you pay him his dues, I think he's happy. You are happy.
Lordship will not indicate anything in the order, my lord. I'll just informal instruction I may take, my lord.
May put in a line with regard to
No,
that
my lord,
aspect, my lord.
not at all. In that case, my lord.
Then they will also, at least his undertaking may be written.
No, not undertaking, my lord.
My lords, may I have it tomorrow?
You take it, you.
It'll take time because, my lord, the officers from, my lord, here and then Delhi, all this has to be consulted. It is, my lord, it is not a person's, my lord, decision. The company has to, my lord, corporation has to take a decision. It is not that a particular officer can give the, my lord, instruction.
If my learned friend has
My
to
lord, I
take
am not,
instruction.
my lord, this is, my lord, just because it has fallen from your lordship that whether it can be sorted out. So I am saying that informally I may try, but otherwise I am agreed by the.
Seeing everything, seeing the entire issue. You know, at the end, if it goes to the council, you might be biting off more than you can chew. I'm telling you the interest given to MSME is huge.
I understand. I understand.
Because I did one matter as a lawyer long time back. A few I did. And the interest that he got was quite huge, quite huge.
That is true, but the interest part is there, but here the question is, my lord, execution of works contract.
Anyway,
It
I'm
is
just,
not
that's
good
just
for
my,
good for
just-
services.
I'm not on the merit.
Fix this matter in the next week, my lord, I'll obtain, my lord, there's nothing to be recorded. That is my lord, submission before the court. Definitely, I'll not, my lord, say that this was not
Okay, right.
submitted by me.
As a matter, if I may be permitted, my lords, may put in a line that I will approach their top management also with regard to this, that let us settle it off. We'll discuss it. Let him invite me over a cup of coffee. My client will go down and meet their top management, my lords, with regard to this. I have completed the work. It is nobody's case that I did not do the work. I am out of pocket by 11 odd crores. They deposited the TDS as well. And there were other 4 agencies I pointed out in my rejoinder affidavit before the learned single judge, my lords, to whom each and every one they paid money.
There's no cross appeal, my lord. He did not.
No, I am not.
If at all he was aggrieved, my lord, we should have prepared an appeal, my lord.
I am sorry. They appeared before the MSME. Manus 203 days delay in filing this review petition.
That has been condoned.
I know it has been condoned, but your conduct needs to be
There's no
pointed out.
question of
before this
reopening
one. I am
what has
sorry.
already
I am
been
sorry. Your
completed and
conduct
decided by
needs to be
this
pointed out.
Just a minute.
Manus, in August.
I cannot hear myself think also. You're like shouting so
I'm
loud.
so sorry, my lords.
So
The delay part has already been, my lord,
they
gone, my
appeared
lord. That has
before
been
the
heard, that was
MSME.
argued.
My lord, my learned friend is not let me submit also.
So, my lord.
just a minute. Just a, we cannot decide this issue today.
That's what I'm saying. Notice may be issued on the next date, my lord. It can be
No.
decided.
I do not know whether this issue. I can decide it. Only problem is I've got to give you a chance to be heard. That's all. Actually, I've already decided, but luckily for you all, I don't have the time. Yeah, because then he has got a single bench also.
Your lordships may
So-
either have it tomorrow, my lords, if he is not going to, or at least invite me over for coffee. His
No, why?
client, well, this is a way of.
What?
I am not asking. I am saying my client, the respondent, will meet their management with regard to the fact that let us finish it off at the single judge's order with whatever nominal interest. I am out of pocket by 11 odd crores, my lords. I am a small institution. On one hand, we keep on talking about Make in India, and then we squeeze the contractors. The foreign company ran away. I did the work. They have benefited from that work. That highway is functional. There's not even a single complaint against me even till date.
Anyway, Mr. Counsel, that issue
I know.
is beyond our hands. Okay, that's beyond our hands.
That's what I'm
The only
suggesting
issue is with regard to the review, and the review is because of the finding. This court can easily say that there is no case for review made out. Okay, because when you look at the grounds, there are 5, 6 grounds given, and that cannot be. You cannot have a re-hearing of the entire. But very clear. You be very careful also. You have got to tell your clients to be reasonable, because if the way you have put all these issues here, it amounts to basically having a re-hearing on the entire matter. So that cannot be done. So please tell them to, try to solve this issue.
So I'll convey the message, Lordship.
Okay, right. Mr. Which is this item?
21, my lords.
Mr. P.S. Aikya, then senior counsel for the appellant, the review petition.
Well, before your Lordship, with a technical issue, this question has come to my mind, my lord. So therefore, I think I must point it out to convey to your Lordship as well, my lord. Well, under the Guwahati High Court rules, my lord, when both the honorable judges are not there, then the Chief Justice is to assign a bench.
Correct.
Right. So by the order dated 21/8/2025, while condoning the delay, my lord, an observation is there, my lord, to the effect that registry to process the review petition number so and list the same before this court on 10/9/2025. Now, whether this regular DB or my lord, this court comprising of the my lord, the earlier
This
bench.
court is a larger term, means the Honorable High
No,
Court.
that's,
my
I
lord.
just my lord, pointed out.
It is, you see, he has not given any name.
That's it said this court. My lord.
This is this court, because right, you see, this court means court number DB1. So right now we are having, we
Yes,
are
yes,
DB1
yes,
right now.
yes. That's my lord, just question came because this court.
No, no, it's,
so I just,
but usually
it's my
what
duty to point
happens
out.
is, they write the name, the judge's name. If they want a particular judge, then they write the judge, otherwise it goes to the court.
It's usually the. That's me, I just.
Okay, right. Mr. P.J. Saikya, the learned senior counsel for this review petition, submits that the that a review that the review petition has to be allowed in view of the fact that the observations and findings made by the division bench at the time of disposal of the appeal would have settled disputed questions which were to be disputed questions of facts before the solicitation council constituted under the MSME Act. Mr.
Mohit Paul.
appears for the respondent. Mr. P.J. Saikya shall appeal instruction from the review petitioner with regard to whether a settlement can be made between the parties.
But if it comes as a direction from the court, my lord, that would be better because,
I said, okay, shall appeal instruction. What more do you want?
Nothing.
Did I say that you should settle?
No.
I can't say that. Shall appeal instruction whether settlement can be made between them. That's all. This is the matter.
Malas can have it on 19th, Malas.
19th of?
Next week, Malas, 19th September.
My lord,
I don't know.
Even 19th will be, my lord, next week, my lord, it'll be, my lord, week commencing from 22nd. Next week, that week
Okay.
I'll be out, my lord, from 15 onwards.
When do you want?
Any date, my lord, commencing from 22nd, 9th. my lord, subject to question.
22nd if then.
22nd.
Obliged, Malas.
Can be on 24th.
No, I am.
No, it's
not aware. Let us do it on 22nd.
22nd under Metro, my lord, I'm sorry to say, my lord, I might have to go to Italian bench. So
Then let it
sounds
be
like
19th, Malas.
Itanagar
But
is
there's not much of a difference between 19th and 22nd because on weekend there.
it's lucrative, more lucrative.
No, I'm saying, Malas, let it be on 19th because on Saturday and Sunday, as it is, their department is not going to be working. So whatever instructions has to come will be there.
19th.
Let it be on 19th,
No,
Malas.
no, 19th I'll be out of station only, my lord, the whole week. my lord. So, can you let it be on 22nd? We'll see, my lord, if possible, my lord, because
16th.
any, I have to choose.
Okay, 22nd.
Sorry, 16th, it should be. 16th. No, that holds in.
22nd, Malas. Deeply obliged, Malas.
May I please, your lordship?
Yes, madam.
Lordship, here my case is that, your lordship. I have a home loan, your lordship.
Do you have a home?
Home loan of
Home loan.
rupees 40 lakhs, even 40 lakhs, your lordship. No, this is the admitted part, your lordship. Yes, your lordship. I defaulted some EMIs, your lordship. And as per record, as the statement of account, your lordship says, your lordship, that I have 13 EMIs pending amounting to rupees, if lordship will come, case number 31, your lordship.
No, madam, the long and short of it.
Yes, lordship. Lordship, I'm on the, lordship.
There is a
Just precise-
possession notice issued.
Notice,
Possession notice
notice issued by,
13-4 has been issued,
yes, yes, my asset has been taken over by the bank,
taken over.
by the bank.
You have filed a section
Seven-
17
Yes,
application,
yes,
rejected. Now, what is the, as per the SARFAESI Act, if the section 17 application is rejected, what is the next
Yes,
course
yes,
of action
yes,
if you
Lordship.
agree
That-
with it?
yes, Lordship, that Lordship, what happened? My issue before this honorable court, not the irregularities made by the bank under section 13 of the SARFAESI Act, your Lordship. My issue solely on the basis, on the ground of my prayer to upgrade my account from NP to standard asset as per 4.2.5 clause, your Lordship, issued by RBI, your Lordship. That much my prayer before the bank, your Lordship.
You see, madam, at the end of the day,
Lordship.
that may be your prayer, but the fact remains that that the section 13-4 application, the notification, is still standing, is still valid.
Yes, Lordship.
And it is a
Lordship,
special-
Lordship.
Huh?
And it is an
Special law.
Lordship, I'm coming to that, your Lordship. Lordship, kindly see
You
the
see, we are skirting around the bush.
Lordship.
Why,
Why I am just insisting this honorable court, your Lordship? I have some grounds, your Lordship, to my limited
no, why
understanding.
don't you, this application that
Lordship.
you're submitting here,
Yeah,
why can't you go to the DRT?
yes,
While you
DRT law.
go under section 18,
yes.
you also take up this issue.
No, Lordship. No, Lordship. They are not have the jurisdiction. They don't have the jurisdiction to resolve this issue, your Lordship. To upgrade my account from NP to standard asset. Why I'm saying your this, Lordship. Lordship, if you kindly come to section 17 of this act, your Lordship, of the SARFAESI Act. May you read the section 17, your Lordship?
Yes, yes.
Yes. Any person, including borrower, aggrieved by any of the measures referred to in subsection 4 of section 13, taken by the secured creditor or his authorized officer under this chapter, may make an application along with such fees as may be prescribed to the debt recovery tribunal having jurisdiction in a matter within 45 days. This is the part of the limitation, your Lordship. Now, if your Lordship kindly come to subsection 2, the debt recovery tribunal shall consider whether any of the measures referred to in subsection 4 of section 13 taken by the secured creditor for enforcement of security are in accordance with the provision of the Act and the rules made thereunder. That means, your Lordship, what I convinced this honorable court, your Lordship, the DRT and DRT is confined. Their jurisdiction is confined to the matter if any irregularity is committed under section 13, your Lordship. Now, my issue is different, your Lordship. Because, your Lordship, if your Lordship kindly see, Lordship, in the meantime, your Lordship, I made a prayer before the...
Look, madam, why has the issue is you have not paid your loan.
Yes,
the long
yes.
and short of it is that you have not paid your
Pay
loan.
the loan, your Lordship.
So they've taken possession of your property.
A property, Lordship,
Simple,
Lordship, simple thing.
Your Lordship, the basis of issuance of 13.2 is the declaration of account as NP, which we have done.
Correct.
And if we have done wrongly,
13,
the guise of the guidelines.
subsequent is 13-4.
No, no,
Yes, sir.
Lordship.
13-2 has already been issued.
13.2 has been
13
issued, 13.4 has been issued, and we
That
have
has
taken the
been tabled-
physical possession.
Your Lordship.
At the last lap of the proceedings, they have come up with
They have
the
come with this.
Because, your Lordship, it is a financial inconvenience of the part of the petitioner.
Financial inconvenience.
But,
Madam, the thing is this. It's a simple thing. Madam, please listen. The thing is this. You have already availed of the SARFAESI Act. 13.2, as he said, let us read 13.2.
Yes, sir.
Come to 13.2. Yeah.
Yes,
Let us
sir.
see 13.2. What does it say?
It starts from notwithstanding anything.
No, that is all right. 13.2. Where any borrower who is under liability to a secured creditor under security agreement makes any default in repayment of secured debt or any installment thereof, and his account in respect of such debt is classified by the secured creditor as non-performing assets.
Yes, yes,
So
yes.
NPA.
Yes.
Now, so then what happened? Then the secured creditor may require the borrower by notice in writing to discharge his full liabilities to the secured creditor within 60 days from the date of notice failing which the secured creditor shall be entitled to exercise all or any of the rights under subsection 4.
Yes, Lordship.
Now,
Lordship.
your uh, loan has been declared NPA and they have got the right to make a notification under 13.4.
Lordship.
Now they have made an application under, they made a notification under 13.4 because your loan is a NPA.
NPA.
Now you want your NPA status to be made into a standard
Asset.
one.
standard
Asset.
Standard one. And
Standard asset, Your Lordship.
standard asset.
Asset, Your Lordship.
Standard asset. Under which provision?
Yes, Your Lordship.
That
That
is,
is, I'm
they are
providing, Your Lordship.
giving a guidelines of the
It's the
RBI.
guidelines of RBI, Your Lordship. It's a master circular, Your Lordship, 4.2.5 clause, Your Lordship, which provides, Your Lordship, the NPA can be converted to a standard asset on the payment of.
And who can convert this?
It is the bank.
It is the bank, Your Lordship. Yes, Your Lordship. But, Your
So
Lordship.
why is it coming to us?
Because, Your Lordship, the judgments are also there of some courts, Your Lordship. And if Lordship permits me.
Council, Madam Council, look. The mark, say the class 10 certificate can be issued by the board, by the education board,
Lordship.
School of Secondary Education or whatever. Can it be issued by the High Court?
No, it's not like that. If
Now,
Lordship.
now you see, who has made your loan an NPA?
The bank, Your Lordship.
Bank.
Hmm.
Now, that making of the NPA has been put to challenge by you because 13.4 has been put to challenge, and that has been rejected by the bank.
No.
Now you go to the bank again.
I am a Lordship. If with due respect, Your Lordship, I am not on the point regarding the classification of my account as an
Fine.
Your Lordship. I am on the point, Your Lordship.
4.2.5. If upon payment.
I am ready to
She
pay
is
the.
stating that she is ready to make the payment.
I am ready to pay, Your
But she
Lordship.
has not paid.
I am ready to pay, Your Lordship.
When you pay it by tomorrow, we will do it.
Lordship, I'm ready, Your Lordship. Paid by tomorrow, today itself, Your Lordship.
Let him pay.
Lordship,
Can
I'm
pay.
ready, Your Lordship.
Consider.
No,
Lordship.
Lordship, my dilemma is that we have already declared the NPA and we have taken the physical possession.
Okay.
And at the last lap of the entire proceeding, they have come up.
No,
Have recalled the account loan facility.
no, let us stop there. Just a minute. What she's saying here might not be in terms of her petition. Let me see.
Please to give the direction to the respondent authorities to update the NPA of the petitioner against loan account number so and so to standard asset on the event of payment of all arrear outstanding along with the interest as on the date as against the aforesaid loan account by petitioner as per clause 4.2.5 of the master circular.
She's asking for setting aside.
And your lordship, please to set aside an order dated.
Set aside, madam.
Lordship, because why I have made this prayer, Your Lordship.
Very smart.
Otherwise, Your Lordship, the impune fact will intake, Your Lordship, remain, Your Lordship. So, Lordship, kindly, if Your Lordship kindly give me permission, I'll pay the entire.
You can bring this issue up with the DRT.
Lordship, I have bring the issue, Lordship. That was never heard, Your Lordship. That was not
We will
heard.
direct now.
Lordship.
Where is your section 18 application? Where is your section 18 before the DRT?
Not filed, Your Lordship.
Yeah.
It was section 17, Your Lordship, where one IA has been filed, Your Lordship.
And with the IA what?
Seeking that, Lordship, I want to upgrade my NPA account on the event of payment, let the bank authority to restore my, hand over my things, Your
Give
Lordship.
me a check, give the check. Give the check to me. Tomorrow give it to us.
Lordship.
Let her bring. We'll pass the order now. We'll see where we'll keep it on hold.
I did not pay, Lordship, with the permission, Lordship. I'm ready to pay. If there is an observation, I'm ready to pay, Your Lordship.
She is ready to pay.
Ah.
Your lordship, the EMI was due much before.
No, she's ready to know. Till with interest till today.
Yes.
With interest till today, she has to pay.
Lordship.
Is that it?
Lordship. The
Then-
area amount, the area and the area amount 30.
No, the principal also.
No, principal lordship, I couldn't, your lordship.
No.
Well, I can't, your lordship.
Principal has to be paid also. What do you think?
Because your
Your
lordship,
Lordship, she
by
may be,
clause
may be
4.
given a liberty.
Madam, nice try.
Lordship, 4.2.5
I've heard you, sorry.
cleared your lordship. So, and your lordship,
Madam, the Supreme Court has said, Supreme Court has said, this is in PHR Invent Educational Society 2024 SEC Online. High Court will not entertain a petition under Article 226 if an effective alternative remedy is available to the aggrieved person or the statute under which the action complained of has been taken itself has been taken itself contains a mechanism for redressal of grievance.
my lordship.
And in this case, forget about whether there's an alternative remedy. You have already availed of that remedy.
That remedy I have availed. I have prayed before the TRT, your lordship, to
Heard, miss?
lordship kindly my matter, because it's a simple matter. your
You see,
lordship. Kindly,
that simple question
lordship.
will now have to be decided by the Supreme Court if you go there. For us, we are bound by the decision of the Supreme Court. Now, if you think that our decision is wrong, it will be. You can always go there and tell the Supreme Court that it is that this is your case, and they will decide.
Otherwise, my
But-
case is not on that, your lordship. The irregularity is
Heard
committed.
G.
by
Bora,
section-
learned counsel for the petitioner. Also heard Mr.
M. Sharma, your lordship.
M. Sharma, learned counsel for the
For the, your lordship, for 7, 8. No, 7 and 8. 3 to 8. Yes, sorry. Your lordship, 3 to 8.
for 3 to 8.
And for respondent number 1,
Miss
RR Saikya on behalf of SKN.
Ara Sakya and we have Miss Committee. Respondent number 1.
And
Who is for 2?
your lordship, 2 is the state of Assam.
No need. Right. The petitioner, who is a loanee, seeks upgradation of his non-performing asset against the home loan account numbers. That's a non-performing assets, double S. Account numbers LBG UW 000040 575 4160 and LBG UW 40 5848 788 bracket mortgage insurance loan to standard assets, on the promise of making payment of all arrears all interest arrears
Area, principal area and lordship interest area, lordship.
on payment of all the principal. Just now you were saying interest only. You're changing, you're like a chameleon.
No, your lordship.
By the time we know that you have changed color. By the time we know. So now you are willing to give everything.
No, not in that one, lordship. Area amount only, your lordship.
What?
Area outstanding, your lordship.
Outstanding area amount.
Yes, lordship.
Without the principal. Without the
The
principal.
13 EMI area, lordship. The 13 EMI's area, 6,95,000 that are in the record, your lordship.
Just say outstanding area amount. With interest, as on date, against the aforesaid loan amount. Next paragraph. The petitioner's counsel submits that the prayer of the petitioner for upgradation of his non-performing assets to standard assets is permissible in terms of is this clause or what?
Your lordship, clause.
Clause, your lordship.
2.5.
4.2.5.
2.5. of the
RBI guidelines.
master guidelines, revised master circular, revised master circular.
2 April 24, Your Lordship.
Huh?
2 April 24, Your Lordship.
2
April.
2nd
April.
April. Where is it? No, 1st April, 2nd April.
2nd April.
Oh, this is a letter. This is a master circle, which is as follows. Huh? You take this down. Okay. Next part. You have made this prayer before the thing.
Has never been considered, Your Lordship. And even the I has never been heard, Your Lordship, by the RT, Your Lordship.
The next para, the petitioner's counsel submit that the above prayer had been made by the petitioner before the DRT, Debt Recovery Tribunal, bracket DRT, Guwahati, which was rejected.
Not rejected, not heard even.
Well,
87 December.
whatever was made before the DRT Guwahati. However, the same was not considered
And heard.
or decided
Decided.
by the DRT Guwahati. The further case of the petitioner is that though there is a default on the payment of 13 EMIs by the petitioner, the petitioner is presently paying the current EMIs regularly.
Lordship, it is active, Your Lordship. I'm paying my EMIs, Lordship.
But so you have got any arreared EMIs? You have
Otherwise, the account is active, Your Lordship.
account may be active, but you still have got area EMI.
Lordship,
She
Lordship.
submits that the petitioner has some area EMI as on date. Mr.
M. Sharma, Your Lord.
M. Sharma, the learned counsel for the this is the learned counsels for the respondent. On the other hand, submits that the writ petition is not maintainable in view of the fact that the petitioner had already had already approached the DRT under section 17 of the SARFACI Act on account of the notification issued under section 13 bracket 4 of the SARFACI Act made by the respondent bank. The same being rejected, the petitioner would have to file an appeal under section 18 of the SARFACI. Thanks. We have heard the learned counsels for the part. As can be seen from the stand taken by the petitioner in the present writ petition, the petitioner wants the upgradation of his non-performing assets to standard assets in terms of clause 4.2.6 of the master circle issued by the RBI. Full stop. However, the declaration of the petitioner's performing assets, non-performing, the declaration of the petitioner's loans as non-performing assets have been made by the bank under section 13(2) of the SARFACI Act. In view of the petitioner not having repaid and having continued to default in his repayment of the loan, despite his loan amount being declared NPA, the respondent bank had thereafter issued a notification under section 13 bracket 4 of the SARFACI Act, taking possession
Possession of the asset.
over the assets of the petitioner. The section 13 for notification issued by the respondent bank was thereafter put to challenge by the petitioner before the learned DRT. However, the same was dismissed. As can be seen from the above fact, the declaration of the petitioner's assets of the petitioner's loans as NPA has been made under section 13(2) of the SARFAESI Act. And the consequential section 13(4) notification has been upheld by the DRT. Section 18, Section 18 of the SARFAESI Act provides that any person aggrieved by an order made by the DRT under section 17 may prefer an appeal to the appellate tribunal within 30 days from the date of receipt of the order of the DRT. The above section 18 clearly shows that the statutory remedy available to the petitioner to make a challenge to the rejection of the application under section 17 is available to the petitioner. In the case of PHR Invent Educational Society versus UCO Bank and others, 2024 SEC Online FC 528, the Supreme Court has held that the High Court should not and will not entertain a petition under Article 2 to 6 of the Constitution, if an effective alternative remedy is available to the aggrieved person, or the statute under which the action complained of, has taken itself and has been taken, and complained of has been taken. Itself contains a mechanism for redressal of grievance. For redressal of the grievance. In the present case, the section 17 application making a challenge to the section 13(4) notification also takes within its fold the declaration of the petitioner's loan as NPA in terms of section 13(2) of the SARFAESI Act. Consequently, when a challenge has been made to the declaration of the petitioner's loans as NPA by the petitioner under section 17 and the same is rejected, the petitioner would have to avail of the statutory remedy of appeal provided under section 18 of the Act. In view of there being a statutory remedy available and in view of the decision of the learned, in view of the decision of the Honorable Supreme Court, as indicated above, the present writ petition, we are not inclined to entertain the present writ petition. The writ petition is accordingly dismissed. The above being said, the appellant is always at liberty to bring out No, to,
Avail the statutory
Huh?
remedy. Avail statutory remedy.
to bring to the notice of the appellate authority the issues that have been raised by the petitioner in the present petition.
Your Lordship, otherwise, with due respect, Your Lordship, otherwise, with my one query, Your Lordship, that suppose a deity, Your Lordship, have the jurisdiction, Your Lordship, if any irregularities, they're confined to their jurisdiction, Your Lordship, if any irregularities committed by the bank, Your Lordship, under section 15, Your
Madam, it's
Lordship.
very simple. It's
Lordship.
not a question of applications. It's a question of payment. You go with a check, pay them everything. Your entire problem solved, headache gone.
Otherwise, what, why happen, Your Lordship? Otherwise,
They-
tenure is there, Your Lordship. Still tenure is there, Your Lordship.
Yes,
My senior has left the court, my lord, due to his personal difficulty. So I fear, I prayed your honor.
Mr. Katane, this is a matter.
Forward.
Yes, but otherwise covered, my lord.
Is a covered matter.
Yes, my lord.
Okay, right. Heard, Mr.
Yeah, Ahmed.
A. Ahmed, learned counsel for the petitioners who submits that the present case of the petitioners praying for payment of their for payment of regular grant for payment of grant of regular scale of pay
Yes.
has already been decided by a number of cases, including the order dated 5/8/2025, passed by a division bench of this by a coordinate bench of this court in WPC 3239/2023, Abdul Motaleb and 147 others versus State of Assam and others. This is at page 28. Mr. N.J. Khatane, the learned counsel for the Secondary Education Department, and Mr.
Yes, that's my lord, for higher education.
for Higher Education Department also submit that the present case is a covered case and is a covered case in terms of the order dated 5/8/25 passed in WPC 3239 of 2020. Para 12, we have heard the counsel for the party. Then para 12 and 30, para 12, no, which one will be? No, para 12 or it will be from para 14. From para.
In the order, man.
Okay, there's a para 12 to 17 of the order dated 5/8/25 passed in WPC 3239 of 2020. Is reproduced here in below. In view of the submission by the counsel for the party that the present case is a covered case, the present writ petition is also disposed of in terms of the order dated 12 passed in 12. Correct?
I love Mr.
The writ petition is accordingly disposed of.